May it please your lordship.
Yes.
My lord, this is a 439 application, my lord. The FIR pays 8, my lord. Allegation is that, my lord, petitioner is the owner of a dhaba, my lord. He has, my lord, he has hanged one banner, my lord, regarding, my lord, supporting Brendanwala, that, my lord, separatists, and some lines, my lord. And he is behind the bars for 25 days, my lord, today. And the case was registered on 1st of April, and he was arrested on 1st of April. And the maximum punishment is 3 years in the LS offense.
So whether this section 153A will be attracted here.
Well, possibly not, my lord, because I have not said anything against any other community, religion, anything, my lord. Only I have hanged one banner.
Yes, madam.
Yes, Lordship, it's a kind of representations of something that is not. So Lordship,
But,
can you give us a time?
But,
Lordship,
and
will
3 years
produce the case
punishment, my lord.
Would it amount to promoting enmity between two different groups?
Yes,
Hmm.
but since it is registered under section 153A, Lordship, can you give us a short date? We'll produce the
But
case for
maximum
it
punishment
because
is 3
mens
years.
rea is required.
But maximum punishment is
So
3 years, my
that
lord.
is we do not know.
First
Case
25
for you
days
will given, Lordship. Kindly, Lordship, can it be on 5th, 6th, Lordship?
6.
Yes. It's from Bongaigaon PS.
Let the city come then.
Yes,
Got it.
Lordship, 6th.
6.
oblige, my lord.
Item number 2.
May I please your lordship? Under section 439 CRPC. FIR case number 11.
Page number?
11.
Let the city come.
Yes.
My lord,
So
Annex
Lordship,
C,
yes, Lordship.
petitioner was soon arrested.
Soon?
Soon arrested on 1/4/2024.
Anyhow, we'll
Earlier
peruse,
case-
CD, Lordship.
we'll peruse the case diary. Case diary on
On Lordship, 8th.
8.
Yes, Lordship.
Okay.
On 9, Lordship.
No sort date.
And
8.
8, Lordship, 8.
Item number 4.
Oblige.
With your lordship, this Mrs. Saikia, she requested me to just ask for the Passover. Maybe she has got some other court. So it may be taken up after some time.
After some time.
I'm ready.
Item 5. Item 5.
None appears for the petitioner on call. Recessal is the matter after 1 week.
Item 6.
May I present the lordships?
Hmm. Yes?
My lord, this is a criminal petition, my lord.
Hmm.
I have challenged the FIR as well as the charge sheet and the proceeding emanated therefrom. My lord, what has happened? An FIR had been lodged, my lord, is at page 38.
Yes.
Lord, the relevant part of the FIR, my lord, is at page
Yes.
42, my lord,
Yes?
42.
Yes.
To the officer in charge of Tarabari Police Station, information about the child marriage. Accused two has been specifically named, my lord. May I kindly have a note, my lord. Sir, I would like to inform you that I know a person, namely Mr. Soyencho Khandakar, has a 17 years old daughter, namely Mahinur Begum, and she was forcefully married to a man, namely Sanidul Islam, during the month of August 2021. This fact came to know my knowledge when I noticed that the girl was not seen with the family. Initially, I was informed by the family that the minor girl was visiting her relatives. However, when the girl visited her parents' house recently, I came to know that the girl was married and now she is also having a baby. Later, I came to know that she was forcefully married off in lieu of the money which was offered to her parents. Further, it is also learned that the marriage took place in a traditional manner in presence of relatives of both the victim girl and the groom. Therefore, I request you to take necessary legal action against the perpetrators and to register a case under the proper section of law against the accused person and take appropriate action against the child marriage which is illegal. Lord, we are not for this accused number. I am not for this accused number 1 and 2.
Hmm.
Lord, what has happened? I am the Muslim marriage registrar.
Pardon?
I am a Muslim marriage registrar, my lord.
Hmm.
My lordship has once gone through, for that, my lord, for convenience of my lordship, my lord,
Hmm.
and go for this statute, my lord.
Hmm.
My lordships can straight away can come to page 50, my lord, this manual.
Yes.
My lord, here, this is the Assam Muslim Marriage and Divorce Registration Act of 1935. Had been enacted, my lord, in the year 1935, a pre-independent and a pre-constitutional, my lord, statute. Herein, what the government is empowered, my lord, may kindly turn to page 52, my lord.
Hmm.
Section 3, I am referring, my lord. State government may grant license to register. The state government may grant a license to any person, being a Muslim, authorizing him to register Muslim marriages and divorces which have been effected within the certain specified limits on application being made for such registration and may revoke or suspend such license. Now, my lord, in exercise of this power, I have been conferred with the license. My lord can verify. I have annexed my license, my lord.
Hmm.
Is that
No,
page?
Mr.
Milo.
Borgoya,
My lord.
this is just let notice go
Yes.
and we'll call for the record.
My lord.
Director will hear you.
And my lord, the proceeding which is, my lord, I have been issued summons
Hmm.
to appear and to face the trial, which is absolutely, my lord, is an abuse of the process of law. I have discharged a duty, statutory duty, my lord.
Okay,
lord.
we'll consider your pair. Let a record come.
Yes.
Immediately after receiving the record, we will hear you on the point of interim pair.
Yes.
Because, my lord, the next date is coming on 16th of May. my lord.
Alright, you take it that from the court below. It is
My
not
lord,
that the heaven will fall on that day upon
But
you.
if my lordship, if prima facie, my lord, if my lordship allows me, I can satisfy my lordship today basing on the record that this case is not at all maintainable against me, my lord. I have not committed any wrong, my lord. Because, my lord, if my lord, they have said that I have registered a child marriage. If my lord, just for a moment, my lord, peruse section 8 of this manual, my lord, is at page.
Okay, we will see the
My-
record. If
my-
the age of the victim girl
No,
is
age of the victim girl is 17, my lord.
17.
I'm
Yes.
17, and I have been empowered under this statute to register even a marriage of a minor girl, my lord. That is the statutory prescription, my lord. And if I do not register, then I will be again subjected to proceeding under the, my lord, by the government can take up action against me, my lord. My lord, may kindly see section 8. This is therefore, my lord, government has revoked. My lordship is well aware, my lord, this statute is no more in force.
Mhm.
It has now been revoked, my lord.
Mm.
Section 8, my lord, subsection 1. If the application, my lordship has got it, my lord, is at
Mm.
page 53. Section 8. Every application for registration under this act shall be made to the Muslim register orally as follows. If the application be for the registration of a marriage by the parties to the marriage jointly, provided that if the bridegroom or bride or both be minors, application shall be made on their behalf by their respective lawful guardians. Here is a case, my lord, wherein this provision has been invoked and the lawful guardian has approached me orally. By examining, I have to, my lord, register. There are directions from this honorable court in a series of writ petition that, my lord, I cannot deny registration. By exercising this, my lord, I have registered. Now I have to face a criminal proceeding for a offense which I have not committed at all, my lord. Kindly see the, my lord, brevity of this RC, section 6, 7 of the, my lord, POCSO and Child Marriage Act has also been added against me, my lord.
That's why,
Why not?
without granting any relief in favor of you, without
Why?
hearing the other side, mainly the victim, since this section 6 and 17 of the POCSO Act is there,
My lord, my
it
lord.
would not be proper on the part of the court to grant any
Lordship,
relief.
since POCSO
Yes, my lord.
sections are added.
My lord, that is also an aspect, my lord, I have to submit fairly before my lord, as there is a direction from this honorable court also.
Mhm.
In POCSO cases, my lord, the informant is required to be heard. That's why, my lord, I have made the informant as a party also, my lord.
As per Deepak Nayar's-
Let
Why?
notice go at this instance.
My lord.
Heard Mr. A.R. Bhunya, learned counsel for the petitioner, and Ms. S.S. Bora, learned traditional PP for the state respondent. This application under section 482, rated section 397, 401 of the Code of Criminal Procedure is preferred by petitioner, namely Abdullah Khan,
My lord.
for quashing the special POCSO case number 33 of 2023 pending before the Court of Learned Additional Session Judge cum Special Judge POCSO Borpeta, arising out of Tarabari PS case number 6 of 2023 under section 7, 9, 10, 11 of the Prohibition of Child Marriage Act, rated section 6/16 of the POCSO Act.
17,
Six,
Lordship.
seven,
Sorry,
17.
17 of the POCSO Act.
6 of the 7.
It is to be noted here that a noted case has been registered on the basis of one FIR. FIR is at page number
Lord, FIR is the page number 44.
38, Lordship. Page 38.
Yes, my lord. The relevant part is at page 42, my lord.
one Asuk Khan. No, Asak Khan.
My lord.
Asak Khan on when it was lost
My lord, it is dated on 2/2/23,
on
my
2/2/2023.
lord. My lord.
2/2/23. Where is the petition and the grounds mentioned therein? Let notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 2 be taken by this
By the local
As
police
per
station.
Lordship mandate of Deepak Nayak case, Lordship.
as per mandate of
Deepak Nayak case, Lordship, since POCSO sections are added.
step upon respondent number 2 be taken within two working days from today
My lord.
to the learned additional PP.
Lordship.
No formal notice is required to be issued to the respondent number 1 since Ms. S.S. Bora, learned additional PP, appears and received notice. However, extra requisite copy of the petition will be furnished to her during the course of the day. Recess will call for the scanned copy of the record from the learned court below. List the matter on. Correct.
On 17th May,
Interim pair of the
Can it
petitioner will
before
be
17?
considered
Next date is
after receiving the record and
Before
on
17.
appearance of the respondent number 2.
on 9th,
my lord.
on 9th May.
My lord.
Item number 7,
Obliged. That is a lawsuit.
My lord, in this case, my lord, the present petitioner, my lord, in before a Jimma petition before the learned trial court, my lord, and a learned trial court, my lord, his Jimma petition has not been considered, then petitioner before the division petition before the learned session court, and learned session court, my lord, also we find that in P note at page 53, my lord, and the ground, my lord, that the amount the found in the petitioner's the study, my lord, he said the violation of the income tax
Where
act.
is the impugned order?
Yes, page 53, my lord,
11 portion.
or 11%, lots you will find at page 58 and 59. Page 58, there are 8 million. 58. It's 58. The petitioner is not an FR and amicus, my lord. I kept it all this money for purchase for land, my lord, and promissory note, hand notes, all the things I placed before the learned trial court, my lord. And I also prayed whenever court showed that amount to be placed before the court, I'm ready in any conditions, my lord, though I relied Supreme Court, Guwahati High Court, as a master's high court, which had decisions, my lord. The learned court had a violation of income tax, my lord. This is not a case in here in this case, my lord. Sorry.
So how many revision petitions you have preferred before the court below?
Yes, my lord. My lord, earlier I have before the CGM, my lord, and twice before the CGM, my lord. Then, after rejection of the CGM court, my lord, I preferred finally revision court before the third district and session judge, my lord. This is the imperial order here, my lord.
So, is there any dispute that you were the owner of the sum of rupees 39 lakhs 60?
Yes, my lord.
That is the
620.
admitted position, Lordship. That is the admitted position. The Lordship kindly come to paragraph, Lordship. Uh, uh, 59. Paragraph 8, Lordship. Page 59, paragraph 58. May I read, Lordship?
Yes.
Another aspect of the entire matter is that the petitioner took the plea that the cash amount of rupees 39 lakhs 620 was collected by him as loan from friends and relatives in order to purchase a plot of land. Therefore, the admitted position that according to the petitioner, he collected a cash amount of rupees 39 by way of loan. That is,
The Income Tax Act section imposes restriction. This is the findings.
yes.
No,
Because he has
without
taken
a,
exception.
without a complaint being made in that respect, whether the court below is entitled to examine that matter.
Yes.
Lordship, so to that regard, we need a report
Because,
from the IO, Lordship.
the trial court was dealing with a petition under section 451 CRPC.
Lordship,
How can he examine this issue?
there is a restriction access.
Hmm? Is there any complaint under the Income Tax Act?
So to that
Mhm.
regard, we need the case records along with Lordship, because,
Let the record come.
yes,
Say, my lord, my humble plea, let the session, the district court to reconsider a petition again, my lord, considering these facts, my lord. If you
Which one?
disorder by my lord, regulating the learned to assess the second session that may be directed as per the provisions of 451 to decide our matter, my lord. That one may be that action.
No, perhaps the court below has dealt with
All the
other
records are
aspect
there,
also,
all the
not
records.
only this aspect.
we need a report also whether Lordship electronic gazettes is a matter of confiscation, whether it is still required. So that is, with to that regard, we need a report, Lordship.
Hmm. Let the record come.
Yes, Lordship.
Heard Mr. P.K. Dekar, learned counsel for the petitioner, and Ms. Assis Bora, learned additional PP for the state respondent. In this petition, under section 482 CPC, read with article 227 of the Constitution of India, the petitioner Shri Gautam Roy has put to challenge the correctness or otherwise of the order dated 29/1/2024 passed by the learned session judge Kasar Silsor in criminal revision petition number 183 of 2024, as well as the order dated 19/8/2023 and 3/10/2023 passed by the learned judicial magistrate Kasar Silsor. Here is the petition in the documents placed on record. Let notice be issued to the respondent, returnable in 4 weeks. As Ms. Assis Bora, learned additional PP, appears on behalf of respondent number 1, no formal notice is required to be issued. However, extra requisite copy of the petition be furnished to her during the course of the day. Registrar shall call for the scanned copy of the record of registrar shall call for the record of criminal revision petition number 183 of 2024 from the Court of Learned Sessions as Kasar Silsor. And these orders 19/8/2023 and 3/10/2023 were passed in which case?
My lord, page 28. 19 petition number 1111023 and 1,
In their case number 1371.
my lord.
And also call for the scanned copy of the record of their case number 137 of 771 of 2023 under section 120B, 420, 294A IPC. Read with section 14 of the Assam Game and Betting Act. From the Court of Learned Judicial Magistrate Kasar Silsor.
Yes.
List the matter after 4 weeks. Interim pair of the petitioner. Is there any interim pair?
My lord.
Interim period of the petitioner will be considered after receiving the record from the learned court below.
Deeply obliged.
Courts
Obliged.
below.
Deeply obliged.
Item number 8.
May I please, your lordship?
Yes.
482 application quashing the trial court proceeding, my lord. Here, my lord, the petitioner and respondent number 2, their relation was husband and wife, my lord. Their marriage was solemnized on 12/12/2021, my lord, as per the Islamic rites and ritual, my lord. After that, my lord, 10 months, my lord, the wife, that is the respondent number 2, my lord, lodged an FIR against the husband and against the mother of the husband, my lord. And accordingly, the case registered as Mukalma PS case number 498
Hmm.
of 2022 under section 498A oblique 323 oblique 34 IPC, my lord. Later on, my lord, the IO filed a charge sheet, my lord, only, my lord, section number 498A, my lord,
Hmm.
and against the only petitioner, my lord, husband, my lord.
Hmm.
After that, my lord, section number 2, my lord, that is the wife, my lord, and against 2 cases, my lord. One case is CR case for recovery the Istridhan, my lord, and another case filed, my lord, DB case for monthly maintenance, my lord. Later on, finally, my lord, the petitioner and, my lord, the wife enter the mutual agreement, my lord. There is a mention for the mutual divorce also,
Hmm.
and accordingly, mutual agreement, my lord, the husband petitioner, my lord, given rupees 1,50,000 as a permanent element. I am coming, my lord, that annex, my lord,
Hmm.
given 1,50,000 as a permanent element, and later on, my lord, they returned the Istridhan, which was took earlier, my lord, at the
Hmm.
time of marriage, my lord. That was the return by the wife, my lord.
Hmm.
After that, my lord, the petitioner and the, my lord, respondent 2, my lord, mutually file a petition for divorce, my lord. That is Pula Talak, my lord, before the register of the Muslim marriage and divorce, Nalbari, my lord.
Hmm.
Accordingly, their petition, my lord, the register of the Muslim marriage and divorce, my lord, issue the Pula Talak, my lord. That is the mutual divorce, my lord.
Hmm.
After that, my lord, they also, my lord, filed the mutual petition only before the SDGM, Nalbari, my lord, for withdraw as disposal, my lord. Earlier, filed, my lord, DB case and, my lord, CR case.
Hmm.
Then, my lord, the learned SDM, my lord, disposed this case according to their mutual agreement, my lord. Now, my lord, in the meantime, my lord, the Chief Judicial Magistrate, my lord, Nalbari issued a summons to the petitioner for appearance before the court in connection with the PRC number 447 of 2023, which is arising out of earlier, my lord, FIR, my lord, which was filed by the wife, my lord, before the Mukarma police station, my lord. So, my humble prayer is that, my lord, this petition, my lord, filed, my lord, quashing the trial proceeding, my lord, which is arising out of, my lord, PS case number Mukarma, my lord, and all the case, my lord, it is clearly mentioned mutual agreement, my lord.
Where is that agreement?
Yes, my lord.
Page number?
My lord, agreement, my lord, agreement, my lord. Page number, my lord, 31.
31 onwards, sir.
Annex 4, my lord. Page 31.
Relevant, 32.
Yes,
Hmm.
ma'am.
No, there is only reference to the case of DV
DB case.
and CR case.
Yes, ma'am. But in the matter, only the mutual agreement was done. After the executed the mutual agreement, the summon was issued, my lord. And even it is also mentioned, my lord, kindly the page number C, my lord, page number 37, my lord. Annex 5, my lord. Page
So
number?
this CR case number 254.
Yes, my lord, it is come,
It
my
is
lord.
pending before the Court of Learned, JMFC Nalbari.
Yes, my lord.
And
But-
DV case was also pending before the Court of Learned SJM Nalbari.
Yes,
And both the cases have been withdrawn.
yes, my lord. My lord, kindly see the page number 37.
But where is the reference of the present case?
My lord, page number, my lord, 28, my lord. It is the annex of 3, my lord. Issue the small, my lord. This order was passed, my lord, learned Chief Judicial Magistrate, Nalbari. This is the impung, my lord, proceeding.
No, that's all right. But where is the agreement between the parties to dispose of the present case, to withdraw the present case also?
Yes, my lord. Yes, mention, my lord.
Where?
Yes, my lord. Yes, my lord. Page number 32, my lord. Page number 32, para 1, my lord. They are clearly mentioned, my lord.
This point number 1.
Yes, my lord.
No, that is CR case 25420.
Yes. Regarding this, my
2020.
lord, kindly see another page number 37, my lord. Page number 37. They are clearly mentioned that mutually application by the both party, my lord. Page 37. Page 37. Middle para, my lord. Middle para, last line, my lord. We are also bound to withdraw all the case filed against each other on earlier occasion. They are clearly mentioned, my lord. This is the mutual application, my lord. Signed by the both party, my lord. Petitioner and my lord, petition number 2, my lord. They are clearly mentioned. Earlier, each other any file against any case, my lord, that should be withdrawn.
Okay, but at this stage, let notice go, let her
Yes.
appear.
Let them appear first.
In the meantime, my lord, please to stay the and suspend, my lord, the trial proceeding, my lord.
After appearance of the respondent, lordship.
But it's a 498A section, my lord. And it is also reflected, my lord, order which is passed by the SGGM, my lord. They have
No,
done the mutual agreement, my lord. It is
Mr.
also clearly
Rahman,
mentioned, my lord. In the meantime, my
if
lord,
they have resolved to withdraw this case also,
yes.
then you could have filed this
Joint
petition
petition.
as joint petition.
Yes.
Then we would have no problem.
But this summon, my lord, come later on, my lord.
Hmm.
All are done, my lord, before this notice summon, my lord.
Hmm.
Later on, my lord.
Heard
2022,
Mr.
my lord.
S. Rahman, learned counsel for the petitioner, and also heard Mr. Ashish Bora, learned additional PP for the state respondent. In this petition under section 482 CRPC, the petitioner, namely Mumtaz Ali, Mohammad Mumtaz Ali, has tried for quashing the proceeding of PRC case number 447 of 2023, pending before the Court of Learned Chief Judicial Magistrate Nalbari. Here is the petition and the documents placed on record. Let notice be issued to the respondents returnable in 4 weeks. State upon respondent number 2 be taken by registered post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Ms. S.S. Bora, learned additional PP, appears and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Recess call for the scan copy of the record from the learned court below. Mr. Rahman, learned counsel for the petitioner, submits that the dispute is between husband and wife, and there are as many as 2 more cases, being domestic violence case number 4 of 2023 and CA case number 254 of 2022 were pending before the courts of learned SGJMS Nalbari and learned JMFC Nalbari respectively, and by deed of agreement dated 2nd of June 2023, which is annexed with the petition as annexer number 4, have already settled the same, and in view of the annexer 5, which is enclosed with the petition as at page number 36, the parties are also bound to resolve all the cases pending between them, and therefore Mr. Rahman submits that further proceeding of the PRC case number so and so may be stayed till returnable date. Having considered the submission of Mr. Rahman and also considering the submission of Ms. Ashish Bora, learned additional PP, and considering the annexer number annexer number 4 and annexer number 5, this court is inclined to stay further proceeding of PRC case number 447 of 2023 pending before the Court of Learned Chief Judicial Magistrate Nalbari till returnable date. List after 4 weeks.
Pleasure.
Item number 9.
Please, your lordship. Well, I'm challenging an FIR, my lord. I've come for a quashing, my lord. The basis of my challenge before I take my lord to the FIR, my lord, that it is a purely commercial dispute as made out in the FIR itself. And no criminal offense having been made out from, if we go by the, assuming that the FIR is correct, and therefore the FIRs ought not to have been registered, my lord. Secondly, my lord, that section 420, 406, 34 has been tagged, my lord. 420 and 406, my lord, cannot go together, my lord. And thirdly, my lord, all the family members, my lord, the brother, sister, the widowed mother, the
No, whether the investigation is completed here.
Not yet, Dr. Hobson.
my lord, my lord, I would put the question like this, my lord, whether a criminal investigation is required on the face of the contents of the FIR, my lord. That is the question I raised for my lord's consideration, my lord. I'll place the FIR, my lord. And my lord, if you go by
So,
the
Madam, Supreme Court has issued some guidelines in the case of Niharika infrastructure. So, going by those guidelines, court's hands are tied in quashing the FIR.
my lord, going by what the Honorable Supreme Court has said, my lord,
Mm.
I would persuade my lord, my lord,
Mm.
if we, let me place the, my lord, FIR, my lord, if my lordship is satisfied whether it is at all a criminal case.
No, this court is not entitled to examine that aspect at this preliminary stage because investigation is still going on. If the IO does not find any materials against the other family members, definitely he will not find charge sheet against you.
My lord, I would persuade my lord on this, my lord,
Mm.
that the brother and sister, my lord, brother and sister, they are students are pursuing higher studies, my lord. They need to fill up forms wherever they go for any institute.
That's all right, but you have already been granted the privilege of PRS bail and bail also.
Yes, my lord. Yes,
Mhm.
I appeared. My statement has been recorded, my lord.
Mm.
That is not the issue. My lord, in that case, my lord, even if you go by what the Honorable Supreme Court has said, my lord,
Mm. Have you gone through that judgment, Niharika infrastructure?
my lord, let
Is
it
it
be.
available with you?
No. Yes, my lord, it is.
If the FIR reveals the prima facie case, Dr.
Yes.
then-
Yes, if that is what, my lord, if my lord finds that there is a prima facie case, then my lord, I will stop.
Mm.
If my lord finds for the FIR that there is any prima facie case,
Mm.
any ingredients of the sections, my lord, I will stop, my lord. Page 26, my
No,
lord.
at this stage, that cannot be examined in view of that judgment.
Yes.
My lord, let it be taken up at 2, my
Okay,
lord. I'll-
let the at this stage notice go. Let notice go.
My lord,
In the
I
meeting.
will
see
call for
maybe
the case diary.
scan
My
copy
Will
of
see.
CD.
Heard Ms. B.S. Goel, learned counsel for the petitioner, and also heard Ms. S.H. Bora, learned additional PP for the state respondent. In this petition, under section 482 CRPC, it is section 397 CRPC, the petitioner. 5 petitioners, namely Srimati Jyoti Daga, Krishna Daga, Mrs. Tara Devi Daga, Deepak Kumar Hirawat, and Bimal Hirawat has prayed for quashing the FIR of Tangla PS case number 11 of 2024.
Yes, Dr. Tongla.
Have you-
PS. Tongla. PS.
my lord.
Is it correctly mentioned, the case number in the cause title? 2024 of or 204?
My lord, it's 2024, my lord.
24.
11 of 2024.
It should be 2020.
Under section 420, 406, 34 at this. That is today noted here that above noted case has been registered on the basis of one FIR lodged by one Gautam De on 4/2/2024. Perhaps the petition and the documents placed on record. Let notice be issued to the respondents returnable in 4 weeks. State upon respondent number 2 be taken by registered post and also by usual process within a week from today. No formal notice to the respondent number 1. Since Ms. S.S. Bora learned additional PP appears and received notice, however, it's a requested copy of the petition be furnished to her during the course of the day. Ms. Bora shall publish the case diary of Tangla PS case number 11 of 2024 under section 420/406/34 IPC on next returnable date. Entire pair of the petitioner will be considered after perusing the case date.
Item number 10,
My lord, may I just say that in the cost title, I may be just permitted to collect.
No, by hand you cannot. There is one notification, you have to file one IA.
item number 10,
My lord, can I date be fixed?
Yes, Kobe.
after 4 weeks,
Date.
29th May.
I'm grateful, ma'am.
May I please, Your Lordship? My lord, you have challenged the, my lord, impugned order that your lordship will find at page, my lord, 58, the first order, my lord,
Page number?
page 58.
Yes.
This is, my lord, first order, my lord, the accused Rupchandal is absent without any steps. Issue NBWA against him, fix on so and so, so and so. Then, my lord, next order lordship will find at page 59.
Page number?
Page 59, my lord. The accused Rupchandal is absent without any steps. NBW issued against him has not returned. Issue fresh NBW against accused Rupchandal. Next date, my lord, 13th also. Then, my lord, another order lordship will find at page 60. Similar, my lord, NBW was issued, page 60.
No, in page number 50.
58,
No, there's a earlier order.
page 59.
No, you have referred to page number 50 also,
58, my lord.
not 50.
Yes, 58.
What's
From 58, my lord, there are 4, my lord, NBW issued against the petitioner. Page 58 first, my lord. Then page 59.
So,
Then
the thing is that you remain absent on that day, therefore the court below has issued non-bailable warrant of
Yes.
arrest.
Now, last order lordship will find at page 61.
Yes.
My lord, dated 23, my lord, accused so and so, so and so. Next date is given, my lord, on 10/5/2024.
Hmm.
Now, lordship will kindly, let's see the previous order at page 56. my lord.
Hmm.
Page 56.
Hmm.
Lordship 14.
Yes.
Yes, it says, my lord, case record put up today as the fixed date was declared, penned down a strike by the All Assam Judicial Employees Association. Accused Rupchandal is absent. Care was shown by the learned counsel of the accused by petition number so and so, dated so and so, with a prayer for fixing another date. Prayer is allowed. Issue summons to the PWs. The prosecution side is to take the steps. Fix on 4/8/2024 for evidence. The prosecution side. Now, all along, my lord, prior to that, my lord, the NBW, my lord, he was appearing through his engaged counsel. But because of, my lord, communication gap between the petitioner and the, my lord,
What
advocates,
communication gap?
my lord, the next date, my lord, fixed,
Hmm.
as lordship has seen, that was not communicated to the petitioner. Because of that, my lord, he failed to appear. Now, in
No,
any case,
is it not your duty to inquire from your counsel?
yes, that is
When the date has been fixed by the court?
yes, that is there. My lord, negligence is found against the my lord, petitioner also.
Hmm.
Not in any case, my lord, he is ready to appear before the trial court on the next date fixed, my lord.
No, you show the grounds for which you could not appear before the court below.
Yes,
Hmm,
That
This
is the word.
communication gap, this is a vague term.
yes. This is the my lord, only ground, my lord, we have been instructed, my lord.
Yes, madam?
Lordship, after taking cognizance, Lordship,
Hmm.
someone should go to the accused, Lordship, as per section 87 of CRPC.
No, that is all
That is
right.
one.
Yes,
He appeared before
He
the
appeared.
court below.
yes. Lordship. So due to
No.
certain reason, he has.
Subsequently, he
He will
remained
be
absent
found
without any
absent,
step,
Lordship.
and his counsel also did not take any step.
Yes. Lordship, at least if he is inclined to appear before the trial court.
Positively, my lord. In the next date, my lord, he will appear, my lord. Till then, my lord, the NBW will kept in abeyance.
Heard Mr. Mandal, learned counsel for the petitioner, and also heard Ms. S.S. Bora, learned additional VP for the state respondent. In this petition under section 482 SRPC, the petitioner, namely Rupsan Ali, alias Rupsan Ali, has challenged the correctness or otherwise of the orders dated 16/9/2023, 9/11/2023, 13/12/2023, and 28/3/2024, passed by the learned special judge Dhemaji in a special POCSO case number 18, which in bracket DH stroke 2019 under section 266, 376. Another thing, madam, this is, since this is under section 6 of the POCSO Act also, we
Yes.
have to not issue notice.
Lordship, at least Lordship, Lordship may direct till 10/5/2024. Next date of appearance, the MBW may be kept in evidence and the trial court will. proceed.
So whether we will grant us a relief without hearing the other side.
Yes, notice should go at least as per Deepak Nayak case,
Hmm.
otherwise. So let the notice should issue first, Lordship, thereafter, Lordship.
Under section 366, 376 IPC, read section 6 of the POCSO Act. Where is the petition and the documents placed on record? Let notice be issued to the respondent number, to the respondents returnable in on short date.
On 13th May,
When the next date is fixed,
My lord, next date is my lord 10/5/24.
10/5 before
on 8th May,
8 May. Step upon respondent number to be taken. Person to in view of the order passed by this court in the case of Deepak Nayak
Deepak Nayak.
versus
State of.
State of Assam. And in view of the practice direction issued in the notification number, what is the number of that notification?
what should I?
Give the notification number to him.
Yes, sir.
Through the learned additional PP within a period of 2 days from today, 2 working days from today. In the meantime, Registry shall call for the scanned copy of the record from the learned court below. Place the matter on.
On 8th
that
May,
file.
Develop this.
item number 11,
May I please, your lordship?
Yes.
The learned trial court discharged me from the charge of the offence. On the revision filed by the private respondent lordship and the complainant, that order has been set aside. The facts remain that the present respondent number 1 as plaintiff filed a suit against me in the learned Munship Tinsukia for declaration of right to the interest and recovery of possession. On that suit, lordship, I filed my written statement and counter claim on basis of a legal notice pertaining to the period of 1985 for a long possession of adverse possession for 35 years. After that, lordship, that suit has been pending at the stage of judgment. The respondent number 1 filed another suit, lordship, my other complaint petition that is pending. That is registered as CR 39/2016, lordship, before the judicial magistrate first class. And in the suit, lordship, they filed another petition under section 340 CRPC, reduced section 195 for perjury, lordship. And that petition is also still pending. And learned trial court, lordship, by order date 10/12/2023, lordship, discharged me from the charges on considering all the evidence and on the ground that a private complaint is not maintainable, since in case a petition under perjury is also still pending, lordship. The lordship, a kind
So
of
this impugned order dated 7/3/2024 is at page number?
at
Is
page number
59, lordship.
59, lordship.
Annex of 1.
Annex of. It starts from page 61, lordship. Judgment. On judgment, Lordship. Relevant portion is start from page 64, Lordship, para 5.
Page number?
Page number 64, Lordship, para 5. Internal para 5. The main allegation in the complaint made by the petitioner.
Whether any of the parties of this revision petition approached this court earlier?
Yes, Lordship. There was a criminal petition. There was on other matter, Lordship, under section 295, that petition.
But there is a reference of this manufacturing of false
Yes,
legal
okay.
notice.
Yes, Lordship.
In that
petition,
case
we have
also?
filed that petition. That petition has been allowed by this honorable court, Lordship.
What was the pair in that petition?
Section 295 for admit or deny some documents also relating to that person. Section 340 clearly mentioned, Lordship, when upon a application made it to the in his behalf or otherwise, any court is the opinion that it is expedient in the interest of justice that inquiry should be made into the offense referred to clause B, subsection 1 of section 195, who appears to have been committed in or in relation to a proceeding in that court, or as the case may be, in respect of the document produced or given in evidence in a proceeding in that court, such court may, after such preliminary inquiry, if any, as it thinks necessary, record a finding to that effect, make a complaint thereof in writing. It is a civil court, Lordship. It is the appropriate court who have recorded its findings and send it to the judicial magistrate first class. A private complaint in respect of the offense, Lordship, forgery, it is not maintainable, Lordship. We have a judgment of the Honorable Supreme Court, Lordship, in this respect. AR 2020, Supreme Court 4247, Lordship. Relevant para 18, Lordship. It is admitted by the complainant, Lordship, a petition of perjury is already pending under the same offense, Lordship. And under the mandatory provision of law, that petition has to be considered at the time of judgment, Lordship. If any forgery is committed, the civil court is the appropriate court who send it to the judicial magistrate first class to take cognizance, Lordship. Therefore, a proceeding can be initiated. Because it is a civil court, Lordship, for the first time when the allegation of forgery is raised, Lordship. So, as the civil court is the appropriate court, Lordship, to send it to the judicial magistrate first class if any offense is committed.
Third, Mr. D. Coletta, learned counsel for the petitioner, and Ms. Assis Vora, learned additional PP for the state respondent. This petition under section 482 CRPC, the petitioner has challenged the correctness or otherwise of the judgment and order dated 7/3/2024 passed by the learned. Additional sessions as number 2 within bracket FTC in Sophia. in criminal revision number 74 of 74 within bracket 4 of 2023. It is to be mentioned here that by the impugned judgment and order that it's doing so, the learned court below has allowed the criminal revision petition number 74 written 4 of 2023 and set aside the order dated 28/12/2023 passed by the learned judicial magistrate first class Tinsukia in share case number 39 of 2016. It is also to be noted here that by the impugned order dated 28/12/2023, the learned JMFC Tinsukia has dismissed the complaint and discharged the petitioners from the charges under section 120B, 420, 468, 471, 34 IPC. Whereas the petition and the documents placed on record, let notice be issued to the respondent returnable in 4 weeks, except upon respondent number 1 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mrs. S. Bora, learned additional copy, appears and receive notice. However, extra requisite copy of the petition be furnished to Ms. Bora during the course of the day. Registry shall call for the scanned copy of the record. No, not scanned copies. Call for the record of criminal revision petition number 74 written bracket 4 of 2023 from the Court of Learned. Additional sessions as number 2 FTC Tinsukia and also the scanned copy of the record of CR case number 39 of 2016 pending before the Court of Learned JMFC Tinsukia. Interim period of the petitioner will be considered after receiving the record from the Learned Court.
Till returnable date of operation of the impugned order will take because matter has been already sent to the learned trial court lordship. If charge has been completed lordship, now this petition will not be immediately effectuous lordship. Till returnable date lordship. I only bear.
Yes,
Let the report come. Subject may be given, let the report come.
But if charge has taken lordship, my this petition will be infectious lordship.
how?
Next applicant.
Because lordship, if charge has completed lordship. So I have come before this lordship against the charge lordship. I have discharged from the charge lordship. And one thing lordship,
Having considered the submission of Learned counsel for both the parties and also considering the facts and circumstances on the record, further proceeding of CR case number 39
13.
of 2016 pending before the Learned JMFC Tinsukia stands stay till returnable date.
Obliged.
Obliged.
Item number 13.
May please, your lordship. My lord, 430 television. My lord, the petitioner is a government employee, my lord, serving now as a CRCC. My lord. Lordship may kindly have a look at FIR at page 10. My lord, the dated 30/2022. May I read out, my lord? To due respect and stated humbly that few days ago, the accused persons had given threat to informant by showing pistol unauthorizedly entered into the house breaking door, attacked the woman member and uses slang language with the accused persons to fear all the house property of the informant by vehicle. Some are destroyed, throwing into fire. The accused persons are trying to kill the informant and family members. Later on, they save their lives by running away. As per information, they have arms like pistol till now. Presently, well, this part is important. Well, presently, the accused persons entered into the land of the informant. Below mentioned person, accused person is earlier involved in the same incident regarding the same patta land with other persons. My lord, who are the other persons? They have not mentioned, my lord. Therefore, in this regard, the one PS case was filed before Mosaic PS on 7/9/2023 by Mosaic PS case number, which is going on. And the accused number 5 is kept in custody about 1 year regarding one murder case. While 5 persons are named in the affair, 1 and 2, 4 has been in the meantime granted bail, my lord. My lord, who are the other persons? My lord, kindly have a look at page 27. land, they have admitted that there is a land dispute, my lord. With some other person with regard to same land. They have not mentioned what is the land, nor that patta, etc. But my lord, that has been my lord, in page 27, my lord. Page 27, my lord. My lord, one Azimuddin Sheikh and Abdul Noor, they have lost an case under section 107, 145, 146 here we see. My lord, here in this case, my lord, kindly have a look at the last paragraph, that land is my land. Then the land is my land, and there is specific order of the district magistrate. The land should be handed over to me. So this FIR has been filed after the attempt of this case is failed, and with some other person. So my lord, basically, my lord, they want to grab my land. And I have annexed the land sale documents also and Jamamudi also. So my land, they want to grab it, and this executive magistrate has directed to hand over the possession of land to me, my lord. When they failed, well, the Azimuddin Abdul Noor, they have instigated this man to lodge this false case, my lord, with so many allegations, my lord. I am a service holder, my lord. It's my land, my patta land, my lord.
Yes, madam.
Accused number 1 and
Yes,
4
they
have
will be
been
there, lord.
granted interim, my lord, yes, my lord, interim bail. my lord. Lordship may call for this case study, and I may be protected, my lord. I am a government employee, my lord. I am a
No, as because you are government employee, we cannot treat you differently.
Civil dispute, but arms act is there, lord.
my lord. They have made out the case, my lord. They have made out the case, my lord, by making some false statement, my lord. They have admitted in the FIR in the second paragraph that we have a dispute with some other person with regard to same land. And who are the person they have not mentioned? That, my lord, that reveals in annexure 4, my lord, demand 4. They are the other persons who are disputing with me, my lord. And there is specific order to identifying that this land is my land, and there is an order of the magistrate to hand over possession to me, my lord. Lordship may protect me by interim, my lord, all for this degree. If anything, my lord, against me, that can be, my lord, cancelled, my lord.
But the allegations are serious.
My lord.
Mhm.
My lord, allegations are serious, my lord. They have admitted that this is original dispute is land dispute, and they have
Maybe.
saying
There is
that
allegation of
pistol
the,
are used, my lord. The accused number 5, there is allegation that accused number 5 is a dacoit, my lord. My lord, he may be, my lord, but I don't know, my lord. But I have been implicated in this case, my lord, because I am the landowner, my lord, and they wants to grab my land,
who, the informant,
my lord.
the
My lord,
informant of this case.
informant, my lord, he is the this FIR has been lost as a proxy FIR of the Azimuddin and Abdul Noor. They have no documents, my lord. There was a land dispute going on, my lord, and the executive magistrate has specifically ordered that this land is belong to me, I am having the patta land, I have purchased the land, and there is the order, my lord, to hand over my possession, my lord. He has nothing, but he has been instigated by these two persons who lost this false FIR, my lord. So, my lord, I may be protected, and case diary may be called for, my lord. That is my humble prayer, my lord.
Heard Mr. Sigdar, learned counsel for the applicant, and also heard Ms. A. Begum, learned additional PP for the state respondent. Apprehending arrest in connection with Huzai PS case number 97 of 2024 under section 448, 427, 325, 294, 380, 435, 506, 34 IPC, read with section 25, 1, 25, within bracket 1, dash capital A, Arts Act. This application under section 438, CPC is prepared by applicant Manik Sundar Devnath for grant of PRSB. Is to be noted here that a noted case has been registered on the basis of one FIR lodged by one Zaita Sahu on 30/3/2024. The essence of allegation made in the FIR dated so is that one Hamidul Haq, Manik Chandra Devnath, Kamaruddin alias Kamaruddin, Haidar Ali, have threatened the informant by showing pistol and thereafter entered into his house, breaking the door and attacked the women members of his family and used slang languages, and thereafter took away all the properties, house properties of the informant in a vehicle, and also destroyed some of the properties by throwing the same into the fire. And also they tried to kill the informant and his family members, but somehow they managed to escape. Mr. Sigdar, learned counsel for the applicant, submits that the applicant is a government servant and that the land in fact belongs to the applicant, and the same is apparent from the order dated 13/2/2024 passed by the learned additional district magistrate Huzai, and that the allegation level in the FIR are false, and in fact the informant has lost the case on being instigated by
Azimuddin Sheikh and Abdul Noor.
Hazimuddin Sheikh and Ami
Abdul Noor, my lord.
Abdul Noor. One Hazimuddin Sheikh and Abdul Noor, and that two of the co-accused, namely Aminul Haq and Kamaruddin alias Kamaruddin Ahmed, have already been granted the privilege of PRS bail by this court by order dated 10/4/2024 in AB number 971 of 2024, and that the applicant is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. Whereas Ms. A. Begum, learned additional PP, submits that at this stage only the case area may be called for. Where having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary, and accordingly it is provided that Ms. Das shall produce the Ms. Begum shall produce the case area before this court on
24th May.
24th May. Having and in the interim, considering the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, especially Annexure 4 of the petition, this court is inclined to extend the privilege of interim PRS bail to the applicant till receipt of the case area. Accordingly, it is provided that in the event of arrest of the applicant in connection with Hosai PS case number so and so, he shall be released on interim PS bail on his executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CGM Hosai without prior permission.
Deep Lovelace.
Item number 14.
Made resolution. Made resolution, 438 application, madam. The FIR is registered under section 379 IPC. One of the FIR initially, one of the FIR was registered as a complaint case. And on being sent to the police, madam, it was registered as a police station case, madam. Civil Sabari Police Station case number 1 of 2024. But allegation is, madam, the theft of the mobile tower. But what happened, madam, as per the allegations made in the complaint, madam, an agreement was signed between the applicant and the complainant company, madam. The mobile tower was installed in my land, madam. That agreement was signed on the 18th of March 2009. The validity of the agreement was till 14/6/2021. So since 15/6/2021, madam, there is no agreement subsists between the parties. Now, madam, in the month of February, madam, some people came claiming themselves to be from the company, madam. They dismantled and madam, took away the mobile tower from my premises. And again, in the month of May, some other set of people came claiming themselves to be from the company, madam, that from the company, and they claim that the tower which was installed here has been stolen away. Only then, madam, I came to know that, madam, the tower has been stolen away because the agreement between the parties had expired on 14/6/2021. I take a lordship first to that, madam. The agreement between the parties. The agreement is at Annex 3, page 22, madam.
Oh, where is the FIR?
FIR complaint has been filed, madam.
That has been treated as
Yes,
FIR.
Yes, subsequently, madam, registered as FIR.
So, what is the allegation?
Allegation is, madam, some miscreants, madam, they dismantled and, madam, and took away the tower, mobile tower. That's
You
what
are
they-
the owner of the land,
I am the owner of the
and
land.
in your land, the company has installed the
Yes.
mobile tower,
Yes,
and some unknown miscreants have stolen the mobile tower.
yes.
And thereafter,
Thereafter, madam, this company came. They claim in the complaint petition. They filed a complaint before the police station, Civil Sabari Police Station. It was not registered. Then again they went to the SP. Even then it was not acted upon. Then, my lord, they went to the court, Learned Court, SDG, Court of Learned SDGM, my lord, Zonai. Learned Court, by order dated 19/12/2023, my lord, sent the
where is the agreement?
agreement. You should find it page 22. Isn't yes, page 22, Annex 3. I am not Indra Pegu. And Lordship may kindly come to the next page, term and license fee. Lordship may kindly see the next page, 1C, madam. The license fee and the period of date. It was till, my lord, 14/6/2021.
So when it was installed?
But sometime in 2009.
2009.
Yes, because agreement is.
And when the agreement was till?
Till 14/6/2021.
14/6?
2021.
Yes. And after the expiry of the agreement?
Yes, but I sent a legal notice to them, madam. You will find that. At page,
So whether they have paid any
No,
rent thereafter?
No, claiming rent, madam, I sent a legal notice to them, madam. 8/12/2022. At page.
But your petition before the learned sessions, the Zemazi was dismissed
Yes, please, ma'am. I have annexed that order,
after
madam.
perusing the case diary.
Yes.
Okay, but let the city come sort it,
Lordship on 30, Lordship.
30.
You have
Thirty.
protected.
Session judge has rejected
Yes,
after hearing the case. Otherwise, we would have considered.
Fine.
15,
Outline.
35.
Lordship for 38 applications. My lord, the FIR may be fined as base time. Base time. Here is the allegation is that the petitioner, my lord, practicing dentistry without having without
This, we have already called for the case
My-
diary.
on
when?
19,
When?
19.
19.
19 May.
On that day, we will peruse the case diary for this.
I have the petition number,
You have not enclosed the orders here.
not enclosed, my lord, the petition which are fixed on 19, my lord,
Yes.
AB number 1043.
AB number 104 of 2024. 104 of 2020.
1043. AB 104.
40, okay.
Published.
item 16,
City will be perused on that day. Rest shall take this application with that petition.
May I please have a
Yes.
430 application, my lord. The allegation is 379 and 411, my lord. FIR is fixed 10 minutes. Well, in the allegation, the informant has alleged accused number 1 and 2 as the persons who have done the offense of 379, my lord. I am accused number 4, my lord. I am the owner of a dump, my lord. May I read the FIR, my lord?
Not necessary.
My lord. Down below, the allegation against me is there, my lord.
Okay.
On the 5th line from the down, my lord. Bottom, my lord. Sold out the same dump of accused number 3 and 4. So at best 411, my lord, maximum is 3 years, my lord.
So you were the owner of a land.
I'm a co-owner, my lord. As per my answer, co-owner, my lord, 3 and 4. That day I was not there, my lord. Accused number 3 was arrested, subsequently released on bail, my lord. But that is 439, my lord. At best 411, maximum 3 years. 379 part I'm not involved, my lord. The 379 part, I'm not involved. That's what the FIR itself.
So you have received the stolen property. 411.
Yes, my lord. What is my instruction is that, my lord, people come and sell, my lord. I was a bona fide purchaser, my lord. Because they come and sell scrap parts and everything, my lord. This broken battery and everything, my lord. I will appear and cooperate, my lord, and we'll let no 41 notice also, my lord. The register on 26/3, my lord. The 2 weeks time has gone. Can you protect me, my lord? I'll
Yes,
appear.
madam.
CD will be there, Lordship. It is there, Lordship, that he have purchased the thing and one co-accused is, he was 439, Lordship. He have been granted bail, Lordship. That is on page number 14, Lordship.
Yes, ma'am. But the co-owner has been.
Heard Mr. N. Mahajan, learned counsel for the applicant, and also heard Ms. A. Begum, learned additional PP for the state respondent. Apprehending arrest in connection with Kolkata PS case number 34 of 2024 under section 379, 411, 427, 34 of this. This application under section 438 service is prepared by applicant Noor Amin for grant of arrears paid. The above noted case has been registered on the basis of one FIR loss by 1 Khairul Bhuya on 26/3/2024. The sense of allegation made in the FIR dated so and so is that on 23rd March 2024, one e-rickshaw belonging to the informant was stolen from Kalgasia Weekly Market. And later on, he came to know that one Monirul Islam, along with one Sarbat Ali, has stolen his vehicle and sold the same in the dam belonging to one Zahidul Islam and Nur Amin. And accordingly, the incident was reported to police, and police apprehended Monirul Islam and Sarbat Ali, and on being laden shown by them. No, in person to the information furnished by them, the stolen e-rickshaw was recovered from the dam of Zahidul Islam and Nur Amin, and Zahidul Islam was apprehended by police, and Nur Amin managed to escape. Mr. Mohasan, learned counsel for the applicant, submits that Section 379 IPC is not affected here in this case, and Section 411 IPC also not affected, as the applicant is a bona fide purchaser of the same, and that the applicant is ready to cooperate with the investigating agency, and therefore Mr. Mohasan contented to allow the petition. On the other hand, Ms. Begum, learned additional PP, submits that at this stage only the case there may be called for. Where having heard the submission of learned advocates of both sides, perusal of the case there is found to be necessary, and accordingly it is provided that the case there be called for fixing the matter on
27th May.
27th. And in the interim, considering the submission of learned counsel for both the parties, and also considering the facts and circumstances on the record, this court is inclined to extend the privilege of interim period bail to the applicant till receipt of the case diary. It is provided that in the event of arrest of the applicant in connection with Kalgasia PS case number so and so, he shall be released on interim period bail on his executing a bond of ₹50,000 with monthly return like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition is shall not leave the jurisdiction of Citizen Borpeta with the prior permission.
Apply, highly applicable.
Item number 18, measure for admission.
This is an application for quashing the complaint, but before that, let me make one thing clear, my lord. In a very limited circumstances, the area lordship interferes, my lord. In a vacant short lordship, it falls under the exceptional jurisdiction area, my lord. Lordship will interfere, my lord. My lord. Second is, my lord, the complainant, my respondent too, on last occasion, he was not present. Today also, I don't know he's present or not. And before that also, we appeared, he was not present, but not recorded. So shall I?
But should we proceed to hear the matter
I
in
want
absence
to
of
make
the?
my submissions because the same thing will happen next day also. Today is absent, last occasion he was absent. The order sheet also you can see he was absent. And before that he is not recorded, but he was absent. We were there. It's a small issue basically. But
So where is the impugn order?
my lord, this is a complaint case, my lord. The complaint has been taken. That's in page number 19.
Hmm.
page number 19, my lord. NHLP. I'll show the complaint. Just lordship will peruse this order. 9518.
Hmm.
Complaint present on period of the complaint petition statement under section 200 CRPC and witness 202. I found sufficient grounds of proceed against the accused and such issue summons. Now, my lord,
No,
please
where is the complaint?
complaint page number 14. Page number 14, my lord.
Hmm.
NHLA. Kindly see the name. His name is Gautam Sinha Rai. There is some reason why I'm saying. And it is not Gautam Sinha Rai. And I am the petitioner Utpal Nandi, my lord. Now come to the next page, my lord, kindly.
Hmm.
See one statement. He is suppressed in the judicial proceeding. Now, paragraph 2, I just repeat it.
Hmm.
The complainant is a businessman by profession. As such, he often used to participate, engage in the trade fair to establish shops in various places of Assam, as well as in northeastern region since long. Paragraph 3 is very important. And the crux of the matter is paragraph 3. Then the complainant begs to state that about 2 years ago, there was a business deal between the complainant and MS Shibam Enterprise, whereby it was decided that Shibam Industries would manage and arrange shop in a trade fair for the complainant, and accordingly, the accused person, being the area sales manager of Shibam Industries, has approached for an advance amount of 4,000 only in cash without furnishing any receipt thereof. Please note this, my lord. The judicial pronouncement will come. Next subsequent, I'll show. Without furnishing any money receipt thereof on behalf of the Shibam Industries. Complainant on good faith paid such and such. This is the crux of the matter. Now, my lord, please come to page number 21, my lord. Please come to page number 21. Page number 21. This is the Shibam Industries filed a petition proceeding under 138 NI Act, my lord. See the name, Gautam Sinha Rai. That's why I said, can you notice the name? This is the name, my lord. In this 138 proceedings, my lord, this respondent number, this Gautam Sinha Rai filed an application in page 40. Please come, my lord, and see what is done. And now I suppress the fact. In that proceeding, his statement kindly see in paragraph 2.
No, firstly, you tell me in this how no, is there any connection between the present petitioner and Shibam Industries?
No. That is the finding also. Lordship will find, my lord. In the judicial pronouncement, I'll show. Just next page, I'll show. First, your lordship kindly see page 40. This question will come here. From here, lordship will get the answer, my lord. Page number 40, NHRT. NHRT. Para 2, my lord. That the accused person begs to state that Utpal Nandi, there is an application under section 91 of the CRPC, praying for issuance of summons and production of certain documents, my lord, that money receipt. They are received without issuing money receipt in the complaint. Now you kindly see here what he says. Utpal Nandi, being the area sales manager, business associates of the complainant firm, has received an amount of 40,000 only in cash on behalf of the complainant firm against the check in question by issuing a photocopy of the money receipt. An original copy of the same has been retained by the aforesaid petition. Photocopy of the said money annexed therewith. Now, my lord, in this case, the Shibam Industries filed this complaint, my lord. Reply objection, page number 42. Page number, yes, 44. Page 44, my lord. See page 45. The first paragraph. Page 45, my lord. In this regard, answering complainant begs to state that complainant is a such and such, my lord. Next 4-5 lines. The answering complainant further begs to state that Mr. Utpal Nandi, the present petitioner in this case, is not an employee of the complainant firm, and said Utpal Nandi has no connection with the complainant firm, in as much as there is no post of area sales manager has ever existed in the complainant firm. The answering complainant further begs to state that he is in charge of the complainant firm himself, my lord. Look after. Now there's a finding by this order by this honorable CJM, my lord, page number 47. Please kindly see, my lord, page 47. Details have been written here, my lord, in this judgment, in this order. 7/6/16. Both sides are present. Order goes to the disposal of the petition number such and such filed by the accused petitioner under section 91 CRPC, stating that Utpal Nandi is the area sales manager, business associate of the complainant firm, has received an amount of 40,000 only in cash on behalf of the complainant firm against the check in question by issuing a photocopy of money receipt, and the original copy has been retained by the Utpal Nandi. The petitioner accused further stated that production of the money receipt of 40,000 only before this court in connection with the instant case is most essential and has substantial importance in reaching a right conclusion of the case. Hence, prayer was made to direct the efforts of Utpal Nandi to produce the efforts document to show as to what amount was paid by the accused against the check in question. The accused petitioner annexed photocopy of the money receipt with the petition. Next. The complainant opposite parties were furnished with the photocopy of the petition to which they submitted written objection wherein the opposite party stated that the averments made by the accused in the petition was totally false, baseless, and concocted, and Mr. Nandi has no connection with the complainant firm. It was further stated that there was no post of area sales manager or business associate in the complaint firm, and the proprietor of the complaint, namely Sudip Bhai, was in charge of the complainant and looked after the entire business affair of the complainant, and he has not authorized any person to collect money on behalf of the firm. It was further stated that money receipt was not under the official paid of the complainant. It was further stated that if, can you see my notice? Next, if Mr. Nandi had issued the receipt, the original must be with the accused. The complainant opposite party stated that the accused filed the petition only for Malavadi gain. Hence, prayer was made, not the findings. Heard both the sides, perused the CR. Now, petitioner accused has not annexed any document to show that Mr. Utpal Nandi was employee of the complainant. The photocopy of the receipt annex doesn't contain the seal and signature of the complainant firm, which would indicate that aforesaid Utpal Nandi was an employee of the complainant firm. Moreover, the document annexed with the petition was a photocopy. The petitioner has not explained why would a prudent man would receive a photocopy of a money receipt after payment, since he is entitled to the original money receipt. The petitioner has not adduced anything by which the court may presume that aforesaid Utpal Nandi is an employee of the complainant firm. I think the accused has filed this petition only to delay the proceedings and considering the accept the petition rejected, my lord. Subsequently, my lord, this order was never put to challenge by this respondent number 2. Subsequently, in that case, my lord, he was convicted, my lord, in 130 proceedings, my lord. And this fact, my lord, was never stated by him. What he has a very good tricks here, my lord. See, the finding is here, there is no original. His contention was, he has given me a receipt. Since he knew there's a judgment against him about the receipt, so he filed a complaint petition saying, without money receipt, he gave the money. See the stand he has changed, my lord. That is the crux of the matter, my lord. Now, in page number 41 also kindly see, lordship, my lord, there is evidence in that particular case. Page number 14 and next page. So the same thing, my lord, with the
Mr. Nath, that's all right, but you see the respondent is absent today.
Yes.
So would it be proper to dispose of this?
I leave your lordship, my lord. I think last chance lordship may give him, because I also don't feel like in absence to argue that way, my lord. Lordship may put
And one more thing, this order dated at page number, this impugn order is at page number
7647.
page number 19.
19, my lord. Okay, cognizance.
Yes, the impugn order.
Yes.
No. You have challenged the order dated
No,
3/5.
and the proceedings, my lord. And the proceedings.
Entire
Okay.
proceeding.
Yes, my lord. Yes. Proceeding. Basically, lordship has seen, my lord. His contention what? Now he changed the stand. He's saying that no, without money receipt, he took the money. But initially he said he gave me money receipt. But when there's a finding against him, he changed the stand. Because he cannot say now he gave me receipt because there's a finding against him. And this fact he has very nicely, tactfully drafted, suppressed this fact and drafted the petition, my lord. But he's caught here. It's clear from the judgment, my lord. And this is judicial judgment, my lord. Lordship can take notice of this. And number 2, Akram Siddiqui case. Just 1 minute. Just one sentence, my lord. I said within the parameter if I can think, my lord. Last line, my lord. My lord. To the effect that in the appropriate case where document relied upon is a public document or where veracity thereof is not disputed by the complainant, same can be considered. Can he dispute his own case, this judgment? He cannot dispute, my lord. So that's why I said within parameter I will show to your lordship. Otherwise, my lord, lordship normally doesn't interfere, my lord. So what to do, my lord? What lordship will pass an order for the next day?
Very short date.
Short date, yes.
Short
Yes.
date.
Fine. Yeah.
Heard Mr. Nath, learned senior counsel, assisted by Mr. D.P. Gowda, learned counsel for the petitioner, and also heard Mr. Koshya, learned additional PP for the respondent number 1. None appears for the respondent number 2, though the name of one Mr. D.K. Samal and Mr. A.S. Batra. It has been reflected in the cause list for the respondent number 2. Rest shall list the matter on Kobe.
On 13th May.
13 May. In the event of non-appearance of the respondent number, non-representation of the respondent number 2 on
Possibility
that
9th
date,
or 10th, any possibility? Just if possible, I'm not forcing.
10th.
Tell my.
in the event of subsequent non-appearance of the respondent number 2, the court will proceed to hear and dispose of this matter without his presence. List the matter on.
Applies, my lord.
Capture 46. No, 46. 46 there. 46 of that. This or two, this. 3 sides in it. 46 of 30 is in it. ঠিক আছে 30 ডিভাইড 30 পিছত 47 48 আছে না আছে এটা খুলি পেলে তাত নিদে ধুনীয়াকে এই কেছটো তলত পেলে খেলিবি নকবি কি দেই মোৰ নাম্বাৰ ঠিক কৰা নাই নহলে ডাঙৰ আছে এইটো ওপৰত দিলে নেকি 19 ওপৰত আছে নাই এতিয়া আছে এইটো ওপৰত 90 ওপৰত আছে হৈ যায় Item 19.
In this case, I have gone for causing of affair on the ground that the second affair, the affair has been lost out of the same cause of action, my lord. And
This is second FIR.
second affair out of the same cause of action.
Where is the first FIR?
The first affair is started page 13, my lord.
Page 13.
First 13. This is the first affair. First affair was by Deputy Registrar, Cooperative Society. As per this allegation, my lord, this present petitioner, my lord, who happens to be the former secretary of this state government, my lord, Bhagatpur Grand Panchayat, has not submitted certain books and record in the Samavaya Samiti for the year 2017 and 18. Subject is, my lord, non-submission of books and records of Bhagatgaon Panchayat Samavaya Samiti Limited for the year 2017-18 with effect from so by Chan Mia Ahmed, ex-secretary of Bhagatgaon GPSS Panchayat Samiti Limited. The year with the one to satisfy the report that auditor could not complete the statutory audit of Bhagatgaon Panchayat for the year 20 due to unable of books and records. The books and records kept by San Mohammed.
Where is the present FIR?
Present FIR annexure 1 to Lordship Planet.
Page number?
Page 10.
Is there.
Former was by the Deputy Registrar of Cooperative Society. Now this has been lost by Assistant Registrar of Cooperative Society.
So on earlier occasion, he could not produce the books and records for the period 2017 to 18 and 19 to 20.
Yes.
And the present FIR relates to which period?
2017 and 18.
Day book 17 and 18.
17, 18.
House or fire case book.
In connection with this matter, I am relying on one Supreme Court decision, my lord,
Hmm.
2001.
So, madam, it appears that the period is same,
Same period.
17, 18 and 17, 18.
Yes,
And this book and records.
yes.
And here also this book, day book
Day book, money
and
receipt,
money receipt
and
book,
voucher file.
voucher
cash
file
book.
and case book,
Yes, for the year 2017 to 2018.
18.
So this is the second FIR, my lord, on the same transaction.
Whether we have called for the record, no, sorry, it is
Lordship, earlier
case
occasion,
diary
a status report was called for
from,
as regard to the Kolaigaon PS case 72 of the 2021 and Dhula PS case 196/21. To that effect, Lordship, we don't have the status report at present. It should be 373/21, Lordship, Dhula PS. 373, present, sir.
This is.
Go to 72. 72 of you. 21 or 373, no?
Oh, no, I should have worked. That's what it is.
so madam, both the case diaries are called for, have you received it?
No, Lordship, till that we have not received the status report.
So is it not necessary to examine both the case diary
So it will be
to
required.
arrive
have
at a
Lordship.
finding?
Yes, Lordship. Will be required. It
Well,
will be
actually, I
suitable.
was informed over phone telephonically that the first FIR that was lodged against me. In that case, police submitted final report. That over only telephone I was informed. Let them get the instruction.
Final report.
Final report is submitted in connection with the first FIR that is lodged against me.
And in respect of second FIR?
Second FIR, no, that is why we are going to check.
So we need the instruction to that. 82196 to be.
It was first FIR.
Third, Mr. I Chaudhary, learned counsel for the petitioner, and Ms. Ashish Bora, learned additional counsel for the state respondent.
In fact, right? No, it will.
The record reveals that by order dated 23rd to 2024, the records on the case diaries of Dhula PS case number 373 of 2021 and Dhula PS case number 196 of 2021 have already been called for by this court, but the same has not been received. In the meantime, Mr. Chaudhary, learned counsel for the petitioner, submits that as per his instruction, in the first case, that is Dhula PS case number 370. 370?
No, first case matter is Dhula PS case number 196 of 2021.
Lordship, kindly come to page 15, Lordship.
Page 15 matter will reveal.
We have got three cases, Lordship. One is Dhula PS case number 06 of the 21. Another is Kolaigaon PS case 72 of the 21. And another is Dhula PS again 196 of the 2021.
So last one may be the correct.
Subsequently renumbered.
So Dhula PS case number 196 2021 under section 406 and 379 IPC the IO has completed investigation and submitted final report. Accordingly, it is provided that Ms. Bora learned additional PP shall obtain necessary instruction from the officer in charge Dhola PS. And on next date, apprise this court about the status of investigation of Dhola PS case number 196 of 2021. And also produce the case diary of Dhola PS case number 373 of 2021. Liston
On 15th May.
15.
15 May. 16 my lord.
Okay.
On 16th May. Item 26.
Everyone.
Hmm.
As per office note dated 24/4/2024, the scanned copy of the case record is not received.
Not received.
Yes, the earlier one is called that was received supplementary case record. On the last occasion, lordship called for the main case record. Office note dated 24/4/2024.
Office note dated 24/4/2024 indicates that scanned copy of the special, which will make it VIZ, which will make it capital T case number 1 of 2020, comma, which was called for from the Court of Learned Special Judge Lakhimpur, has not yet been received by the section. Accordingly, it is provided that Justice shall issue reminder to the learned court below for transmitting the scanned copy of the record forthwith. Place the matter on
13th May.
13th May.
There is interim order that may be.
Till then, interim order passed earlier shall continue.
Okay.
Or you can obtain the relevant copies, certificate copies from there. You can produce the same before this court,
Okay, I have already annexed the judgment, my lord.
certificate copy.
Yes, that is the copy from the certified copy.
No, we found the same
The scan copy in regard to special vigilance within vacancy case number
The
one
judgment
A of the 2010.
The judgment
perhaps
I have
received.
annexed the certified copy, photocopy of certified copy.
All for us 2010. All for us 2010.
2010. Okay, let the scan copy come then.
27.
Okay.
Like this person.
Yes.
Also, this is position come against the Union order dated lawsuit 8/4/2024 lawsuit. The NBW issued as the petitioner lawsuit. And in this regard, so we have had the additional affidavit also lawsuit. In the other occasion, we have annexed the all order lawsuit.
The Imperial order at page 20 onwards. Also. Thank you.
But lordship, in additional affidavit is the latest order lordship, which I have annexed lordship. In additional affidavit is 33 lordship.
Impugn order is at page number
33 lordship, additional affidavit lordship.
No, you have challenged the order dated 26/2/2024.
That is on page 20 in the main petition.
Main
Yes.
petition lordship.
Yes.
Page 20.
NBW is against the accused petitioner Kundal Sinha lordship.
So the warrant against Kundal Sinha was issued prior to this order also.
Yes, Lordship.
Where
Lordship,
is that order?
Lordship,
Which I have added.
it has been filed in, on 36/2012.
Hmm.
It's a long pending Lordship. And thereafter, what are the subsequent orders?
Which I have annexed in additional affidavit also. I have just this.
That additional affidavit copy we have not received.
From page 26, Lordship is onward, Lordship. Page 26, 27, 28. And last one, Lordship, 33. Lordship, the petitioner never received the notice, Lordship. And only when they came to knowledge, Lordship, notice someone to the.
So
bail-
earlier you have been granted bail.
The earlier Lordship was granted 12%.
That's all right, but which is the first order by which a non-bailable warrant of arrest was issued against you?
First Lordship 29/11 Lordship.
29?
29/11/2022.
No, no.
That copy Lordship.
29/11 is not the first order.
Earlier he appeared Lordship after that on the COVID during the.
No,
COVID
you read
incident.
the order. Non-bailable warrant of arrest issued against accused
Yes,
Kundal
from
Sinha has
this
not
date, Lordship,
returned.
only 29 November 2022 from this date only issued a non-bailable warrant. Lordship.
No, no. That cannot be.
Where is?
Earlier also,
Yes, Lordship, this is the only notice gone to the petitioner Lordship. But in the not found in the petitioner is staying in the Impal district Lordship because of his.
no, that's all right, but which is the first order by which a non-bailable warrant of arrest was issued first against you?
And the order of cognizance that has been taken. Thereafter, someone
Hmm.
should go to.
Because if we set aside and quash the order dated 26/2/2024, it will not serve your purpose because non-bailable warrant of arrest issued against.
Yes. This earlier.
Could you
order has
follow?
to be relaxed.
Could you follow?
Yeah, according to. From the initial.
Yes, Lordship, I will produce Lordship.
So, through local council from Silsor, you can inquire by which order first non-bailable warrant of arrest was issued against him. You have to challenge that order
You have the subsequent order.
and all subsequent orders by which non-bailable warrant of arrest was issued against him. The first order. Only then you will get relief. Otherwise, no.
Yes, Lordship,
We can set aside this order. There's a impugn order 26/2/2024. But the earlier orders,
Lordship, I will.
in that case, you have to amend the cause title and payer of this petition also. You have to impugn the first order and all subsequent orders by
Yes.
which non-bailable warrant of arrest was issued against you. Third, Mrs. R. Rangmai, learned counsel for the petitioner, and Mrs. S. Bora, learned additional copy for the state respondent. Recessal is the better on
15th May.
15th of May, so as to enable Mrs. Rangmai, learned counsel for the petitioner to obtain necessary instruction and also to enable her to furnish the first order by which the learned session judge Kasar Silsor has issued non-bailable warrant of arrest against the present petitioner in session case number 40 of 2018. List accordingly.
Item 46. Item number 46.
Here is your lordship. My lord, the matter may pass on for the time being. My senior advocate busy and
Who is this in here?
Mr. Asa.
S?
Yes, Ahmed.
International 46.
Sorry,
Admission.
For bail hearing, item 30. Here it is, lordship. Bail application for 3976. Allegation under section 365. Lordship, petitioners are behind the bars since 74 days today. And the punishment is 7 years. Mandatory period is 60 days. lordship.
She did not receive, lord.
And earlier occasion, for accused is already allowed to go on bail.
Earlier occasion?
For accused Monu Haq is already allowed to go on bail. Page number 20. lordship.
Madam, this he was arrested on 12/2/2024.
Oh.
And section is 365. So default bail.
No.
Hmm.
Because
Where is the earlier order? Granting bail to co-accused?
page number 20. lordship.
20.
Order dated 5th March 2020. Lordship,
So
lordship, one another co-accused Zeneman Begum is also allowed to go on bail by this honor because on 22 April 2020.
Victim girl was recovered from the possession of Jeliman Begum.
Yes, she is already allowed.
you produce that order? So he's behind the bar for more than 60 days, Huh?
More than 70 days, lordship.
70 days.
Yes,
Then 365 is what is the punishment?
7 years, lordship.
7 years. 60 days offense.
60 days, lord.
Heard this, sir?
Is Ahmed.
Learned counsel for the accused and also heard Miss Enda's learned additional PP for the state respondent. This application under section 439 services prepared by accused Vishwajit Das and Sobita Dev, alias Sobita Das, who has been languishing in jail in connection with dispute case number 118 of 2024 under section 365 IPC since 12/2/2024. Thereafter, this order dated 22/4/2024, para number 3, Mr. Ahmed, learned counsel for the accused, submits that both the accused were arrested on 12/2/2024 and since then they have been languishing in jail for more than 70 days. And that the case has been registered under section 365 IPC And the maximum period of punishment prescribed for the aforesaid offense is 7 years. And as such, the mandatory period of detention is 60 days. And since the accused have been languishing in jail for more than 60 days, and since no charge sheet has been submitted here in this case, the accused are entitled to default bail here in this case, and that one of the co-accused, namely Ziliman Begum, has already been enlarged on bail by this court by order dated 22/4/2024 in BA number 1034 of 2024. And therefore it is contended to allow the petition. On the other hand, Ms. Enda's learned additional PP submits that though the case diary was called for, the same has not yet been received. Having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record. And it appears that both the accused were arrested on 12/2/2024, and since then they are languishing in jail for more than 70 days. Further, it appears that the case has been registered under section 365 IPC, and the mandatory period of detention for the aforesaid offense is 60 days. And since no charge sheet has been submitted till date, the accused are entitled to default bail. Accordingly, it is provided that on furnishing a bond of ₹50,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate Kamrup M, the accused persons being enlarged on bail.
Item number 48,
It is.
item 48,
My lord, diary was called for, my lord.
It is.
My lord, this is for 39 application, my lord. There are two petitioners, my lord. Petitioner number 1 is behind the bar since 38 days. And petitioner number 1 is behind the bar since 23 days, my lord. FI is page number 12, my lord.
Petitioner number 2 is behind the bar for
23 days. Relevant portion is at, my lord, page number 15.
page number
15, 1 5.
yes.
May I read, my lord?
Cyber fraud.
Yes.
What happened, well, so far as the affair one Omit Shah and Diya Verma insisted the informant to invest money through WhatsApp. As such, the informant invested money, my lord. But we are not the assignment accused, my lord. And we did not play any role directly in the effort sheet allegation. My lord. Length of detention may be considered. Kindly length of detention.
Length of detention. So what is the stage of investigation?
Lordship, complainant lordship and accused examined lordship. And after examination, both the accused and complainant lordship, there is a note of IO. It is learned that the fraud amount of the complainant has been credited in the current account of the accused Rakibul Hussain and further transferred the received amount to the other involved person, Jiaur Rahman Moinul Rashid.
So, what is the allegation?
Allegation is that, my lord, rupees 11,40,000 has
Financial
been
frauds,
invested by
lordship.
the informant in the name and style of company Pantheon Ventures, a UK-based company. That is the allegation.
So, the informant has invested a sum of rupees.
11,40,000, my lord. My lord, last paragraph of the FIR, page number 16.
In
my
the
lord.
company, namely Pantheon
Pantheon
Venture.
Ventures, a UK-based company. Induced by one Amit Shah and Dia Verma, who are the office bearer of the company.
And fraud amount of the complainant lordship credited in the account of Rakibul Hussain petitioner. And again,
This is
he
a present petitioner.
present petitioner. And further he transferred the amount to Moinul Haq, the second petitioner.
My lord, petition number 2 is a bicycle mechanic. My lord, he is no way involved with this.
Who?
Petition number 2, Manul.
Petitioner number 2.
So here
The
lordship it is stated that Rakibul Hussain further transferred the received amount to the involved person, Jiaur Rahman Moinul Hussain. His name is Moinul Haq. His name is mentioned here.
Hmm. So, what was the amount deposited in that account?
From the complainant 1 lakh.
I have 50,000 in the account of Manul. So was the instruction. My lord. From the recording report of the second accused, rupees 50,000 credit. Well, total amount 6 lakhs. So was the account number, from the account number, total amount 6 lakhs,
Hmm.
what 11 lakhs 47.
So in the forwarding report, it is mentioned that 7 lakhs.
7 lakhs. Well, so was the account details 6 lakhs.
Pardon?
My lord, so was the for my lord, FIR as per account details 6 lakhs, my lord. Page number 16, my lord, second last paragraph, my lord.
Hmm.
Sasansas 1 lakh on dated 18/1/2024. Number 2, my lord, 1.81 lakhs on dated 27/2024, my lord. 1.40 lakhs on dated 22/2024, and 1 lakh on 29/2024.
No, in the last paragraph, he has invested 11.40 lakhs.
My lord, the addition, that's up after several requests, they said the IPOs on 16th December 2024, and I had immediately sent a withdrawal request to return my all loans of 11.40 lakhs.
Hmm.
Then, but they did not pass it, saying now that in the group that all have to pay 17% service fees for Amit Shah and their team to make it so much profit. Yes, I mean, consider the length of retention.
This is in respect of Raqibul Hussain. And in respect of the other accused,
Other only it is mentioned in the IO that Rokibul Hussain transferred some amount to the
Moinul Haq.
Moinul Haq. That much on the lordship in the case.
But this accused also only opened one account. Hmm. IO notice at page number.
That's
Whether this Ziaur Rahman was arrested here,
No, my lord, not yet.
not arrested.
Not.
Heard Mr. A. Parmanik, learned counsel for the petitioner, and also heard Ms. E. Begum, Ms. Endas, learned additional PP for the state respondent. This petition under section 439 services be heard by accused Raqibul Islam and Moinul Haq, who have been languishing in jail as in connection with Cyber PS case number 7 of 2024 under section 42406 IPC since 19/3/2024 and 2/4/2024 respectively. It is to be noted here that Cyber PS case number so and so has been registered on the basis of one FIR lodged by one FIR is at page number
My lord, 15. The relevant portion is at page number 15, my lord.
on the basis of one FIR lodged by one Rajesh Kumar Das on 19/2/2024. The sense of allegation made in the FIR dated so and so is that he has invested a sum of rupees 11.40 lakhs in a company in the name and style Pantheon Venture, a UK-based company, lands in India and one Amit Shah is the head of the aforesaid company and one Dia Barma is his assistant. And later on, he has been seated by the said company. Mr. Parmanik, learned counsel for the accused, submits that but that accused Raqibul Hussain was arrested on 19/3/2024 and accused Moinul Haq was arrested on 2/4/2024 and since then they are languishing in jail. And considering the period of detention, Mr. Parmanik contented to allow the petition. On the other hand, Ms. Endas, learned additional PP, has opposed the petition. And producing the case therein is thus submits that IR has collected some materials in support of the allegation against both the accused persons and therefore Ms. Das has contended to allow the petition, dismiss the petition. Where having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record and also perused the case diary with the assistance of Ms. Das, learned additional PP. It appears that the accused Raqibul Islam has been languishing in jail Hazur since 19/3/2024 and accused Moinul Haq has been languishing in jail Hazur since 2/4/2024. And considering the period of detention and also considering the nature and gravity of the offense, as well as the materials collected so far in the case diary, further custodial detention of the accused person seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate Kamrup M, both the accused persons be enlarged on bail. So you have been caught red-handed there. The petitioner was caught red-handed while he was committing theft.
Lordship,
The petitioner was caught red-handed while he was committing theft.
Lordship,
His address is mentioned in the this page number 31. Ramone Dekka, son of
Lordship, he is not in that address, Lordship. He was tenant that time.
Hmm.
Now he has changed his place actually. No, not even the landlord and the neighbors knows about his knows about whereabout, Lordship.
Okay, let the record come.
Coming item 4.
may it be the Lordship.
Yes.
This revision petition is filed against the order under the minor 9424 at page 55. It's regarding Zimma of the vehicle and under mobile and etc. Learned counsel, on behalf of Zimma petitioner is present, report as called for, so. Zimma, this is not bike or motorcycle, my lord. The vehicle is, only one vehicle is mentioned here, but there are two vehicles. One is a refrigerated van, another is, my lord, I-20.
One is
Refrigerated truck, which is minus degree,
Mm.
refrigerated truck.
Mhm.
And another carrying goods, my lord, frozen food.
Mm.
The vehicle carrying frozen food, that is a refrigerated truck.
Mm.
And my lord, another is I-20 vehicle.
Mm.
The wrongly written as bike and motorcycle.
So the 9/4/2024 is the impugned order dated 9/4/2024.
Yes, before that, my lord, the High Court passed an order. My lord,
Before that?
regarding the
Before that,
Before that, this court passed an order for in the Zimma petition. That is in, my lord, very long order. But my lord, whole case is based on, my lord, false, because, my lord, the incident I.
so now what is your pair in this petition?
There, my lord, for release of the, my lord, two vehicles
Mm.
and, my lord, two mobiles, which is lying there for last 6 months almost. Two mobiles and two vehicles. One is refrigerated van and, my lord, another is personal vehicle I-20. What happened, the background of the
No,
court is
here
that
the learned court below has directed to release the vehicle.
bank guarantee, it will be around 50 lakhs another. My lord, thing is that, my lord, this case is not covered by IPC. This case is covered by the FSSI Act.
Mm.
Food Safety and Standard Act.
Mm.
And this act has the only authority to deal with this such cases. Here, my lord, the police has taken upper hand, and, my lord, it's a big conspiracy by the police to, my lord, intervene. A vehicle was coming from, my lord, Bihar Kisanganj factory. That is more than 100 big factory. They are exporting also a lot of meat, and they are having license from the government India. The meat was carrying from the, my lord, Bihar to Guwahati to be dispatched to Mizoram. The on transit at Srirampur gate, my lord Gosai, they stopped the vehicle, they taken out few packets of meat, and, my lord, they have let the vehicle go, but, my lord, they have stopped all these registration and other thing, they have blocked it. Secondly, my lord, after 2-3 days, they came to the SI came to Guwahati and arrested the, my lord, owner of the cold storage. And, my lord, cold storage, there are so many things. And, my lord, His personal vehicle from Guwahati, Khanapara also taken to Gosaigaon around 7 o'clock to reach there around 3:34 o'clock in the winter, my lord, December month. And my lord, taken out two mobile phones from him, and so my lord court is. And my lord, the IO, although my honorable Supreme Court has specifically written my lord in the my lord specifically given direction in Nevada properties, 3 judges bench, including our Honorable Justice Ranjan Gogoi, the police cannot seize or my lord, the police cannot log the immovable property. That is my lord, Nevada properties.
No,
But-
here, there is no
So, my
question of involvement of this immovable property. Where is the question? Hmm?
This is the written argument I prepared. I place the
You
today,
know,
my lord, actually,
how
today-
that judgment will help you? You tell me.
I think without record, your lordship is not going to pass the judgment, number one.
Pardon?
Now, without the case diary, your lordship is today not going to pass the judgment, my lord. Or your lordship.
No,
because the
case diary may
is
not be
here.
necessary because
ma'am.
we have already passed some orders
Yes,
modifying the conditions. What is your prayer? To modify the condition or to what?
My lord, definitely, my lord, modify the condition, because when the act says police has no power, I want to place only few sections of the act. The
Mm.
police has no power. Your lordship will kindly see first, my lord, the
No,
license given by the government
in
of
this
India.
revision petition, madam, we cannot examine that issue.
At least your lordship has to see
In
the
that
law.
case, you
Which
have to
law?
challenge the FIR.
Which law? That is, my lord, on my lord, Wednesday, and case diary is also there, my lord. Case diary, all records are there, and that is fixed on 1st of May. So either it may come along with this, or your lordship can hear this petition. They are challenging the FIR.
Acha,
For Quasman, my lord, criminal
acha,
petition.
acha. What is the number?
32 of 2000, criminal petition 32 of 24. Already, my lord, that court has questioned where is the power of the police to dispose of the meat of around 10 lakhs. They have come on, my lord, few days back, and my lord, they have taken away the meat of around 10 lakhs. And my lord, where is the power of the police? That court has asked my lord to reply by where is the power to seize such vehicle and my lord meat, because the food authority, food inspector can only do this. If there is some complaint means, my lord, FIR has been filed only by the police. And it's a, my lord, big conspiracy, and without authority of law, they have put the Cattle Act. No leaf cattle is, my lord, no leaf cattle is carrying, because it is a -degree track. Only it carries frozen peas, frozen chicken.
Okay, heard Mrs. and
So
Sylvia,
it may be tagged together and.
learned counsel for the petitioner, and also heard Miss A. Begum, learned additional PP for the state respondent. In this petition, revision petition under section 397, 401, and 482 of the Code of Criminal Procedure, the petitioner Abhijit Soikia has challenged the correctness or otherwise of the order dated 9/4/2024 passed by the learned subdivisional judicial magistrate between bracket M. Gokhaigaon in Gokhaigaon PS case number 381.
Modify
Under section 420, 406, 468 IPC, related with section 13(1) of the Assam Cattle Preservation Act. Ms. N. Soikiel, Mrs. N. Soikiel, learned counsel for the petitioner submits that the petitioner has challenged. The petitioner has filed another petition, being criminal petition number 32 of 2024, for quashing the FIR of Kokaigao PS case number 381 of 2023. And the said petition, no, in the said petition, a coordinate bench of this court has already called for the case diary and
Is there, it is there already.
only
Already there. Last.
at what stage it is pending?
Is there and my lord, records are there, report are there. Whatever necessary records. So hearing took place on that day. And for further hearing, because IO has been filed, IO has been directed to file an affidavit, therefore it is fixed on first. It may come along with that will enough. Yes.
কি কলো তোমার? Already heard the matter and fixed on
First of May.
1st of May. Accordingly, it is provided that Resty shall take this revision petition along with the criminal petition number 32 of 2024 and list the same before the no list the same on 1st of May 2024.
Standing item number 46 for admission.
None appears for the petitioner on call. Resty shall list the matter after 1 week.
Item fixed at 2 p.m. Item number 47.
Right, please, your lordship. 439 application, this matter came up day before yesterday before your lordship, that I have shown to your lordship that in the final complaint at page 32, serial number 60, lordship may kindly see, serial number 60, that the supplier of seized 289.210 gram heroin was Munna Bhai alias Domini. Due to non-appearance of Munna Bhai alias Domini supplier, the role of Munna Bhai Domini is still is under investigation. If any evidence found in respect of him, the same will immediately be submitted before the honorable court. And then your lordship may kindly see the prayer 62.1 that the complainant humbly prays that continuation of further investigation may be allowed in instant case against accused and other suspect person. So that aspect only having to clarified by my learned senior friend whether they have subsequently filed any further report or they have filed any application not to continue that investigation in regard to other accused persons. Otherwise, lordship, the trial will not proceed and till the charges are not framed, lordship. And the petitioner being moment, she is in custody for 6
No, charge sheet has been submitted against how many accused?
against the present accused along with 2 others.
2 others.
Two
Whether
others.
they have been named there?
One, yes, name. One of them is all, as per my instruction, subject to correction is on bail also. lordship. That no, I have checked it and it says lordship notice was issued to bailer also. One of the
So altogether 3 accused have been charge sheeted. Now why the case could not proceed?
Because lordship non-appearance of other accused persons. And
Who are the other accused? The 2 accused, other 2 accused.
accused. And they also said that further investigation they are carrying on, but they have not submitted any subsequent application that they are not continuing any investigation and trial may proceed.
No, can it be said that without such a report, trial court could not proceed with the
Yes, that
trial?
judgment I have placed before lordship on other day that as Mujibur, that it clearly says that when further investigation is going on and the case cannot be split up, lordship.
That S. Mujibur Rahman versus.
Yes, Mr. Kyle, have you gone to the,
Section. Lordship, this is the actual prayer. Whatever is, section 173A. Well, if it is not there, you can,
this volume?
Lordship, section 173(8). This speaks with regard to subsequent further investigation. That will not affect in any way, and this is a normal prayer. And since the accused number 2 is not appearing, the London Trial Court, I have seen the trial court's record also. The process has been issued, and regarding splitting, Lordship, further investigation with respect to other accused is pending. That will not even any effect if the trial pursuits and case is split up, Lordship. The landed, my landed friend has submitted on judgment. Probably this will not come in the way in this case, Lordship. If they files application, definitely it can be split and the case can proceed against the person who are in behind the bar, Lordship.
No, is it necessary to him to file an application to that effect?
No, Lordship, either prosecution or the anyone has to file application for splitting of the case. When process, because learned trial court is
No, is it the requirement of section, any of the provision of CRPC that an application has to be filed by either side?
If court is satisfied.
if the court is satisfied, Lordship.
If the court finds that the attendance of other accused could not be procured,
Then Lordship it can be. But not
it is the discretion of the court.
London trial court, now my land defendant has submitted one judgment. It says that if the investigation is pending, court cannot split up. So in my humble submission, that will not come in this way, in the way of this case, because here Lordship, investigation is complete with respect to accused number 1. And the final complaint has been filed. And with regard to other accused, London trial court has issued process. Warrant has been also been issued. In my humble submission, there is no difficulty if the case is split up.
In the record other day, I have clarified, your Lordship, that court also took cognizance of the fact that they paid for further investigation. In the order dated probably Lordship 18.
No, in fact, the court below has not permitted them to continue with the investigation. They have only reproduced the pair there.
Pair.
The court below has only reproduced the pair.
Allowing or rejecting that portion.
That
is
has not
there.
been mentioned there.
Yes. And
Not
the
been
court's
mentioned.
order is not required for further investigation for them.
Yes, Lordship, it is not required because under section
But
173A,
aspect is
Hmm.
it
taken
is always available to the prosecuting agency to file any.
To
subsequent-
continue with the
Yes,
investigation. Yes.
And in my humble submission, this week, the judgment will not come in the way, particularly in the present case. If the case is split up and the trial is proceed against the present accused person.
Hmm.
My main prayer is that Lordship, that considering the length of detention and the facts which I have placed.
That's all right, but Mr. Ahmed,
Lordship.
in the cases under NDPS Act where commercial quantity is involved,
Lordship.
so this length of detention is irrelevant. You see that Mohit Agarwal's judgment of Supreme Court.
Mohit Agarwal,
Mohit Agarwal, Lordship, that Article 21 was not discussed and. therefore,
21 is
Lordship,
not discussed,
Yes.
but in order to establish that your fundamental right is violated,
Yes,
you have to show that there is inordinate delay.
Lordship. That inordinate delay is nowhere explained as to my understanding, Lordship, that what. we have
Maybe,
found
but
from CRPC, Lordship,
how this delay has to be counted, that has been explained in the case of Air Antole.
and in Satyendra Prasad until Lordship, this point is taken into consideration. Because earlier, Lordship, I'm not intervening. In Satyendra Prasad until, Honorable Supreme Court says that in case of NDPS Act, 436 capital will be applicable.
Or?
436 capital A,
Hmm.
maximum punishment that is to be taken into consideration. And there are so many reasons where Lordship has occasion to deal with all this case. Lordship, I have brought one case also.
No, not necessary.
And Lordship, furthermore, page 30, the contraband was seized from the conscious position of the present petitioner. And that
Position
is
of the?
present petitioner. 289.210 gram of heroin.
Hmm.
That conscious position that I am not on merit of the case, I am only on delay ground, Lordship. That conscious position that even if your Lordship see that the main supplier was someone else,
She was lordship put to carry the article. So whether conscious possession is not there, that is a matter of trial. So I am not on, I am not arguing on.
The conscious possession, what is possession that has been dealt with in the case of Nawaz Khan?
Yes, Nawaz Khan.
Hmm.
That constructive, that I understand. Therefore, Lordship, I am not submitting that aspect in this bail application, Lordship.
Hmm.
This is a matter of.
No, if you were preferring this petition only on the ground of delay,
Lordship,
you have to establish the delay.
Lordship,
Then
therefore,
you
Lordship,
have to establish that prejudice is caused to you.
Lordship. Therefore, Lordship, I am relying on certain judgment. I have given one compilation if your Lordship.
Hmm.
Lordship, may I see that serial number 1, that Ravi Prakash case that I have enclosed, Lordship.
Hmm.
Paragraph 3 and 4, Lordship, may I see.
Hmm. But Mr. Ahmed, you see, in most of the judgments you have relied upon, the Supreme Court has not laid down any law.
But one
Only
aspect,
considering the facts of that particular case, Supreme Court has granted bail.
that one aspect, Lordship may kindly consider that in paragraph 4, it is said that delay will dilute the rigors of section 37.
Hmm.
So that delay.
No, that is established.
Yes, and another
That
aspect,
is,
Lordship
in
may
the
kindly
case that
consider.
one case law you have not relied upon, that Muslim Mandal or like that Muhammad Muslim. In that case, that aspect has been dealt with.
Yes.
And considering the length of detention, that is 436 capital A. In that case has been considered and granted bail to the accused. But here you are languishing in jail as of for how many days?
For 1 year, 10 months, 10 days, Lordship.
1 year,
10 months, 10 days.
10 days. So who is responsible for this delay?
I am in custody and
Yeah.
they are continuing further investigation. Other accused are not appearing, so I cannot blame anyone.
No, is there any fault on any part of the court or on the part of the prosecution side?
Prosecution side, probably they could have Lordship file application that my case may be split up. Lordship,
No,
because they were continuing
you can
investigation.
also, that liberty is also with you. You can approach the court for splitting up. It is not necessary that you have to file a petition. You can advance a verbal prayer also.
Other person's attendance could not be secured. That aspect probably in my humble understanding, Lordship, they have to show it that the other person's attendance.
No,
could
no,
be
not
secured.
necessary. The court can take notice of the fact from the record. Hmm?
I leave it up to your Lordship, but otherwise also Lordship that this period of detention, considering this period of detention, coordinate bench granted bail.
Maybe, but
Only on that.
that is not binding on this court. Because in that case, no law has been laid down.
But coordinate bench judgment is Lordship.
No law has been laid down merely because one bench has enlarged some accused on bail. It is not binding on the other court that
But
because
for that
each and every facts and circumstances are different.
But the ground which was relied on is that delay, Lordship. Delay of 1 year, 8 months.
Hmm.
And here your Lordship's direction was they have to expedite the trial. The trial court. That page 41, Lordship may kindly see. And that direction was in the year January 2023. After I'm coming, I'm again renewing my prayer more than 1 year, 3 months. After 1 year. That page 38, Lordship may kindly see.
কবে? Probably এবং advocate case calculation. Record calculation আছে। বেশি লাগে এক করে করবো এই কেস কিটা লাইভ পঠাই দিবি লাগছে রেকর্ড করে এটা নরমাল তো এসে করলাম বাবা এটা ঠিক আছে মনে রাখতে পারবো আমি কোড চেক করে দিয়েছি এটা আপনি রিপিটাল বিষয় হ্যাঁ একটু বিটু এসটা দেখতে হচ্ছে দিন করে যাবেন no any bail and the case TV side intention about documents আছে oh the documents to decision that is proposed ಇದು ಸೆಕ್ಷನ್ ಒಳಗಡೆ ಎಲ್ಲ ಕೋಆರ್ಡಿನೇಟ್ ಕೊಡಬೇಕು
And in serial numbers 10 of my compilation, your lordship will find one of the person named Anjan Nath, his bail was rejected and then he went to Supreme Court, his bail was granted. Here from the High Court order, I have verified there was also fair that delayed ground was there. He was granted bail on 1 year, 7 months. He was in intercession.
serial number
10, page 23.
and that is maintaining parity with other accused he has been granted bail.
Here also, Lordship, as per my instruction, subject to correction of my learned friend says, one of the accused is also on bail, Lordship. That notice, one of the accused is on bail, that I can place from the record.
One of the accused?
Is on bail, Lordship.
Okay, you go for the record then.
And Lordship, further, I prepared one synopsis. I transferred, sent through soft copy, covering all the points.
All the
points regarding long incarnation, period, bail. I've cited some judgment also, and I quoted the paragraphs. I've sent through email to your Lordship.
One copy may be furnished to me, Lordship. One copy may be furnished.
Lordship,
have you filed objection here?
no, yes, we have filed objection that is on the record.
Okay. Have you referred those judgments here?
No. That is a separate list.
Okay, you go to the judgment or go to the record of trial court. You'll see on what ground that accused was granted bail. We will see.
Lordship, I fixed it on Monday or
Monday.
or-
Okay. As agreed by learned advocates of both sides. Races shall list the matter on Monday, first up to going to second up to division. Yes, 30.
Lordship,
30 April.
I have some.
Acha.
On first or second note.
First of May then. First of May.
First of May.
Okay.
32, bail hearing.
May please, your Lordship. 430 application, Lordship, the FIR is at page 22 and relevant.
Are you on interim?
Yes, your Lordship, I am on interim.
Have you appeared before the IO?
Yes, your Lordship.
When?
A long time back, your lordship, the main accused, the named accused have always been granted bail by your lordship on 6/11/2023.
Where is that order?
That was after filing of this, and on the basis.
Yes, madam, you received the case.
No, Lordship, today have noticed it.
We are not named in this case, your lordship.
Interim is there, Lordship. Interim is there. Interim is there, Lordship. Pick some other day for CD.
The named accused have.
But madam, you see, this petition was filed long back.
On Monday, then Lordship, I will.
More than 6 months elapsed. So in view of that judgment of Supreme Court, we cannot keep the matter pending.
Well, we are not named in this affair also.
We cannot contravene the direction of the Supreme Court.
Yes.
Okay, heard me, sir.
I am.
Learned counsel for the accused and also heard Ms. Endas, learned additional PP for the state respondent. Yes, pair number 2 and 3. Pair number 2 of order dated 11/3/2023 and pair number 3 of the order dated 6/11/2023. Mr. Ahmed, learned counsel for the accused. No, learned counsel for the applicant submits that the applicant has already been granted the privilege of interim PRS bail by this court by order dated 11/10/2023, and thereafter he had appeared before the IO and his statement is also recorded. And since he has been cooperating with the investigating agency, and also since his name has not been mentioned in the FIR and no way involved with the offense alleged in the FIR, it is contended that the interim order dated 11/10/2023 may be made absolute in the same terms and conditions. Whereas Ms. Das, learned additional PP, submits that she has not received the case ID and press for granting her some more time to produce the same. But it appears from the record that the interim order was passed on 11/10/2023. And since then, almost 6 months elapsed, and the learned additional PP was granted sufficient opportunities to produce the case before this court. And therefore, this court is inclined to hear the petition on merit without perusing the case and propose to dispose of the same without perusing the case ID. It appears that the applicant was granted the privilege of interim PRS bail by the order dated 11/10/2023, and thereafter he appeared before the IO and cooperating with the investigating agency. And further, it appears from the FIR and close with the petition that his name find no mention in the FIR. And since he has been cooperating with the investigating agency, his custodial interrogation, comma, in the interest of investigation seems to be not warranted here in this case, and therefore the interim order dated so and so is hereby made absolute in the same terms and conditions.
33.
So see, this is the same FIR.
Here also you haven't granted.
Charge sheet
Look.
submitted, Lordship.
If it counted interim, your lordship, I was the owner of the vehicle in this, item number
Here.
33. Ladies, yes, we are not named in the FIR.
Search sheet number?
Charge sheet number, Lordship, 265/23, dated 30/12/2023. Item number 33 and 34, Lordship, charge sheet submitted.
This is different case.
Oh, lordship, these are arising from the same FIR. Lordship, may I kindly peruse page 15A. The same case.
Same FIR.
Same FIR, lordship. We are not the named accused. My car was used for coming to Guwahati. The police intercepted for that.
No, whether the case number is same.
Sonapur PS case number 201.
No, it is 201, it should be.
201.
Yes.
Yes. Sonapur PS case number
And
201.
the other case? Earlier case?
The same case, 201. 201.
This one.
201/2023.
There were 4 cases in this.
Is it correct?
Something is wrong here. lordship.
Yes, Lordship. In item number 32, Abu Hanif.
Abu Hanifa.
32, 33 and 34, sir. 32, I hope so. Here, Lordship, written as
It is okay.
item number 33 is Sonapur PS case number 201. 33 and 34, Sonapur PS case number 201/23.
This 32 is also same.
Same.
But here, Lordship, 32, Jagi, Yogi Gopa PS case number 60/23, which I have received.
How can it?
Something 32 to same.
Same.
Same. Abu Hanif, Abu Hanif, and oh, wrong petition I have received in item number 32, I have received wrong petition.
The petition is wrong here, lordship.
This
No,
also-
32 is also arising out of the same FIR.
I have received the wrong,
Acha.
wrong petition. In that.
Okay, then we have to correct the order in 32. কি করবো? Submission লৈকে হেৰি কৰি লওঁ। এই endless or submission to modify কৰি দিওঁ। পিছত আপুনি কাটি দিয়ে। Miss Endas learned additional PP submits that she has not received the case ID, but as per her instruction, the IO has completed investigation and submitted search sheet being search sheet number 265/2023, dated 30/12/2023, under section
Under section 379/411 IPC read with section 11A(b)(d) of the Prevention of Cruelty to Animal Act. Read with section 13(1), the Assam Cattle Preservation Act.
Okay. Better. In view of the submission of learned advocates of both the parties, this court is inclined to dispose of this anticipatory bail, pre-arrest bail application by directing the applicant to appear before the learned court below and to apply for regular bail. And in the event of filing such an application, the court below shall consider the same in accordance with law. On or before
13th May.
13 May. You have to appear before the court below. Till then, interim order pass earlier stands extended. So 32, 33, and 34. Same order. Same order.
35.
Sitting of his lordship. Interim is there, lordship.
Pardon?
Sitting of his lordship.
You are on interim.
Yes, ma'am. We are.
Miss Endos learned additional PP submits that she has not received the case diary and press for granting for some more time. To produce the case diary, here is allowed
22nd May, Lordship.
22nd May. Till then, interim order dated 30th/1/2024 stands extended. Apply.
36.
Same prayer, Lordship.
You were on interim?
I'm an interim lordship. They appealed for the higher lordship.
When, madam?
24th.
24th, Lordship.
24.
Lordship.
Okay. Till then, interim order dated 20th to 2024 stands extended.
37.
Skin Pavlovich CD was for pilot.
Service is not complete, so Lordship.
Service not
As
complete.
per the order dated 9th before.
So you
Office
have not
taken.
taken any step? Office note dated 9/4/2024 indicates that no step has been taken for issuance of notice to the respondent number 2. Accordingly, it is provided that learned counsel for the respondent number learned counsel for the applicant shall take step upon respondent number 2 as per notification dated 17/5 17/3
No, 23.
20 17 notification number 17 dated 15 March 2024 through the learned additional PT. And after closing service of notice through the officer answers jurisdictional PS, the learned additional PT shall furnish a report before this court on when? Which PS? Sorry.
On 14th of May,
Sorted.
Lordship, then 10th, Lordship, 10th.
And you take step immediately.
Yes.
Plus. You furnish the step in the office of the PP.
Plus.
38.
CD received, Lordship.
Lordship, my senior is on legs on another court. Also, but not for the pending Lordship. Thank you.
39.
May I please, Your Lordship?
Hmm.
But Your Lordship granted him interim bail. According to 17/4, we appeared and recorded my statement. Appeared, Lordship.
So what is the stage of investigation
Investigation is going on, Lordship.
going on?
Lordship.
Whether his custodial interrogation is required?
Appeared, Lordship.
Okay.
Family dispute.
Heard Mr. S.C. Biswas, learned counsel for the applicant, and Miss A. Begum, learned additional PP for the state respondent. That's pair number 2 and 3. Mr. Biswas, learned counsel for the applicant, submits that this court by order dated 10/4/2024 was placed to extend the privilege of interim period bail to the applicant, and thereafter he had appeared before the IO and his statement is also recorded. And since he has been cooperating with the investigating agency, Mr. Biswas contended that the interim order dated 10/4/2024 may be made absolute in the same terms and conditions. Ms. A. Begum, learned additional PP, has produced the case diary before this court and submits that the applicant had appeared before the IO and his statement is recorded. And further, Ms. Begum submits that investigation is still going on. But having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case diary with the assistance of Ms. Begum, learned additional PP. It appears that the applicant had appeared before the IO and also cooperating with the investigating agency. And in view of above, And also in view of the materials collected so far in the case diary as well as stage of investigation, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore interim order dated 10/4/2024 is hereby made absolute in the same terms and conditions.
Deep top line.
Item 40,
Lordship, regarding item 14, Lordship, we have received the CD few minutes ago, Lordship, so let it be come Monday, Lordship. We'll have to go through today.
Yeah. Ms. A. Begum learned additional PP submits that she has received the case area but could not go through the same and pressed for listing the matter on Monday so as to enable her to go through the case area. There is accordingly allowed. Let's shall list the matter on Monday. Till then, CD will retain.
on 20, much obliged, Your Lordship, much obliged. Item 41, matters for orders.
None appears for the appellant on call. It appears that one Mr. A. Borua is appointed as legal aid counsel, but he was found absent on repeated call. Press shall list the matter after 1 week. Better dead silent.
42,
A. Borua
Well, this is a condonation petition, my lord, in criminal revision, my lord. The delay of 190 days, my lord. The steps were taken through the IU, my lord.
Yes, madam, you received a report.
No, Lordship, we have not received the report. Steps have been taken, no?
Yeah, taken.
For respondent is there, Lordship.
But
Lordship, we have not filed Ukaratama. We have filed Ukaratama.
so this application is under section 5 of the Limitation Act. IA.
Picture to article 131, my lord.
Yes.
Yes, my lord.
It's mistake. I told the I can hear.
This was a mistake, my lord.
When it was passed?
131 was.
Yes, any objection on your behalf?
We
You have
filed-
objection?
We have filed Ukaratama next week along with our written document. And the matter may be-
No, do you have any objection in condoning the delay and hearing the matter on merit?
Lordship, we have not filed Ukaratama. We have newly engaged. We have filed Ukaratama next week. Lordship. And the matter may be taken next.
Adjourn for next week.
Okay, heard me, sir. Your good name?
Okay, Boro, my lord.
MK?
Boro.
Borough Learned Counsel for the applicant.
Well, I'll just have a simple prayer, my lord. He is a CRPF personnel, my lord. The petitioner is a CRPF personnel, my lord. The entire case relates to the maintenance, my lord. They claim that she is my wife, but I said that she is not my wife, not married her. That's the dispute. So my only prayer in the revision petition is that remand back the matter and allow us to contest the case by filing the WS.
No, in
Now,
order
things are-
to pass that order, first we have to
Yes, my lord.
condone the delay.
Now thing is that.
Only then we can pass the order.
There's some thing has developed that he has been dismissed from service. Merely on this ground. allegation. So, my lord, a little short date may be given for that. I'm praying.
Ah, all right. And also heard Mr. A. Lord-
Islam.
Ace Islam, learned counsel for the respondent number 2, and Miss A Begum, learned additional PP for the respondent number 1. Mr. Islam, learned counsel for the respondent number 2, submits that he has been recently engaged and will be filing his power by next week. There is accordingly and price for granting him, and as such he price for granting him some time. There is accordingly allowed. List the matter on
13th May
short date.
10th of May.
or 8th May.
8th May. So you have to file Ukalanama, and also if any objection you have.
They will also have to correct the cost title lordship, 5. The limitation act of 5 is there, lordship.
The legal provision will correct it.
The
Pardon?
cost title.
Court can remind us.
Cost title, for correction of cost title, you have to file IA.
That is lordship.
You have to
I-
file IA. Where is the mistake?
Well, Section 5 of Limitation Act, HCPRD, 131, my lord,
1,
131.
not section 5.
Section 5.
You file IA.
43,
None appears for the petitioner on call. SSL is the matter after 1 week.
items from correction list, item 1, criminal revision petition, 164 of 24.
May I please, your lordship? What's here, the criminal revision is basically challenging the order that 2424. So wherein the application under section 311 recalling of the victim witness that was rejected. So my ground here is that basically, my lord, at the time of deposition, at the time of FIR, at the time of 164 statement, at the time of her statement, there is nothing, there is no statement regarding where she has studied, regarding the age, my lord. Because age has to be ascertained, because the matter leaks with the POCSO Act, my lord.
So address is notice will go.